It is 10 o'clock, and I would like to call the meeting to order. We will first off call roll. I'm Dee Parker, speech-language pathologist. Amnon?
Amnon Shalev, board member, hearing a dispenser.
Marcia Raggio, audiologist, board member.
Patty Solomon Rice, speech language pathologist, board member.
Debbie Snow, public board member.
Karen Chang, public member.
Okay. And at this time, I would like to turn it over to our administrative law judge. I want to pronounce your name correctly.
Good morning. I am Timothy Aspinwall. I am the administrative law judge sitting with the board for purposes of hearing the petition in the matter of Marshall Shoquist. The record should show that we have a quorum present, and we are ready to proceed with the matter of Marshall Shoquist. May I please have the appearance from the Attorney General's office?
For the Attorney General's office, Deputy Attorney General Jansen Tan.
Thank you, Mr. Tan. And the petitioner, Mr. Shoquist, is present. And Mr. Shoquist, you ready to proceed this morning?
Yes.
Okay. So as I mentioned to you prior to the beginning of the hearing, these proceedings concern your rehabilitation since the discipline from which you are now seeking relief. So your discussion with the board should focus on your rehabilitation. This is not a time to relitigate the past discipline. Procedurally, the Deputy Attorney General, Ms. Tan, will first present the case summary to the board, which includes your petition package, which I will mark and admit into evidence. There are also two documents that you have asked to be copied and have been distributed. We will review those, and I will mark those into evidence as well. After Mr. Tan presents the case summary to the board, you will have an opportunity to testify under oath. And I understand you have no witnesses with you today. It's simply your testimony today, correct?
Yes.
Okay. And after you testify, the board members and Mr. Tan will have an opportunity to ask questions of you. First, Mr. Tan will ask questions, then the board members will follow. After the hearing is concluded, we'll go into closed session and the board will deliberate. You will not receive a decision today, but will receive a decision following the hearing by mail. Okay, so Mr. Tan, would you like to present a case summary?
Thank you, Your Honor. I do. Members of the board, Ms. Chairman, Your Honor, my name is Deputy Attorney General Jansen Tan, and I'm appearing on behalf of the Attorney General pursuant to Government Code Section 11522. I'm here to assist the board, the panel, in fact-finding. My role is not adversarial, but is intended to protect the public interest. I'm here to ensure that the panel has adequate information to make a decision. Your Honor, I'd like to start off by introducing the jurisdictional documents. Before you, we have an exhibit binder, Exhibits 1 and 2. Exhibit 1 is the certificate of licensure for Mr. Shoquist.
Mr. Tan, do you have a packet that you would like to have marked as Exhibit 1?
I do, Your Honor. Do you have a copy, Your Honor?
I don't.
Permission to approach, yeah.
Thank you. Thank you very much. I will mark this as Exhibit 1 for identification.
Thank you, Your Honor. So, members of the board, before you is an exhibit binder. On tab 1, we have the certificate of licensure, which, Your Honor, we would like to mark and move into evidence as part of the jurisdictional documents. It is the certificate of licensure of Mr. Shoquist.
Okay.
On tab 2 is the decision and order adopting the stipulated settlement and disciplinary order. Again, we would like to have this marked and introduced into evidence as Exhibit 2 as part of the jurisdictional documents. And we have Exhibit 3, the notice of hearing for today's board meeting, showing the correct address and time, also part of the jurisdictional documents. Your Honor, I'd like to proceed with a case summary by starting that the petition by Mr. Shokwas was filed in July of 2017. The decision in order before you today on Exhibit 2 shows that the decision was effective January 14, 2013, and the decision adopted the stipulated settlement drafted by my office, the Attorney General's office, on behalf of the complainant, putting petitioner, Mr. Shokwas, on probation for 7 years. So 7 years, that counts to January 14, 2013 to January 2020. The petition was filed in January 2017. And in this stipulated settlement, Mr. Shokwas admits to all the allegations in the accusation, in the amended accusation. Part of the penalties to protect the public was the practice monitor, standard terms and conditions, an education course, and of course, customer restitution. Board costs of $4,747 have not yet been paid as of the filing of this application or petition. Proceeding with a summary, the amended accusation charged and as admitted by Mr. Shokwas. The first and the second cause deals with the failure to refund the amount of hearing aids issued to 2 customers, despite numerous follow-ups, and there was even a small claims court decision against Mr. Shokwas. But despite that, Mr. Shokwas was unable to provide this refund. Later on, we will learn in the application that he has provided those restitutions. The third and the fourth cause of discipline is very important to today's hearing, specifically because it refers to a certain standard of testing. In the amended accusation, Mr. Shokwas failed to conduct bone testing or air and bone conduction testing into customers. I will show later on that may still be an issue based on the newly introduced evidence by Mr. Shokwas, the probation monitor's report for 2017 and 2018. But I digress. Moving on to the fifth cause of action, according to the amended accusation, Mr. Shokwas also has issues with his record keeping. Again, this is an issue that may still be an issue based on the probation monitoring evaluation that we have here today. Again, I digress, but I'll move on to the sixth cause. The sixth cause for discipline under the amended accusation is dishonesty. Mr. Shokwas misrepresented to the board and a customer that he wore hearing aids when in fact he did not. The seventh cause of action is a violation of Civil Code 1793.02, wherein Mr. Shokwas' written warranty was not in accordance with the statute. He added certain verbiage to it that disadvantaged customers. This is again against the statute, and based on the amended accusation and the decision of the board, starting from AGO 2, the amended accusation can be found in AGO page 14, Exhibit 2. Based on this decision, Mr. Shokwas was disciplined. Exhibit 4 shows the petition for penalty relief. And in it we have, well, first off, he checks the box that it's a reinstatement for a revoked or surrendered license. I believe that to be untrue because he is on probation. It's not, I don't believe that his license was revoked. The revocation was stayed and it was put on probation. The other point that I'd like to make is that the cost recovery has not yet been paid in full. If ever the board does grant this petition today, we would obviously recommend that the cost be paid in full before such reinstatement. Part of Mr. Showquist's petition shows numerous the narrative statement, numerous attachments such as the narrative statement. An admission that he has paid restitution, and an admission as to the charges in the amended accusation. Noticeably absent is any written recommendation from his practice monitor or any colleagues or any witnesses today that would attest to his rehabilitation. I'd like to stress that that is something that the board might want to consider in whether or not to grant this petition. On AGO 72 onwards of Exhibit 4, we have the probation monitor reports. And what I can tell you today is that the practice monitor does show significant improvement. However, issues still do remain. So this is something that the board needs to consider whether or not to grant this information, or rather this petition. Your Honor, with that said, we would like to move the petition, which is Exhibit 4, and the probation report, which is Exhibit 5, into evidence, marked as Exhibit 4 and 5 into evidence. And at this point, Your Honor, we rest, but we do reserve the right to cross-examine Mr. Showquist after he's spoken, to ask questions in the public interest to show whether or not he truly is rehabilitated and he has addressed these issues. I have nothing further, Your Honor.
So the petition and the packet prepared, which are Exhibits 1 through 6, will all be admitted into evidence. All tabs 1 through 6, Exhibits 1 through 6 are admitted into evidence. The packet, rather than being simply marked and admitted as Exhibit 1, is admitted in its constituent parts as Exhibits 1 through 6.
Thank you, Your Honor.
So, Mr. Showquist, this is your opportunity to say what you have to say, both with reference to the petition packet, which you have in front of you in the black binder, and with respect to the two practice monitor reports that you brought with you today, and anything else you wish to say. As I mentioned during my introductory comments, when you're finished, Mr. Tan will likely ask you some questions, and then each of the board members will do so at their discretion. So you have the floor. First, let me swear you in, if you'll stand and raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? Okay. Be seated and address the board.
I will certainly not regress in terms of the issues that were involved that we were totally admitted guilt for. The relationship with the monitor began with a list of things that I needed to improve in my practice. And so these were things that were included in every report that the monitor produced. The most recent one says that my files were professionally labeled, that the SOAP notes, which are the description of my relationship with the clients and what I do, were included for each appointment of the reviewed charts. Improved organization of the files for easier review, a new purchase agreement to reflect the 45-day trial period, which was a change that came from the board. And then I believe that indicates that my spirit with respect to what I do and the charges that were brought against me have been 100%. I have not spared any time or expense. My practice is easy to do this with because I probably see 3 to 4 people per week. At this state of my life, I would say that I'm partially employed by myself. 99% of the clientele have been previous clients that come back to me. I really don't think that I have anything to say in my defense at all. I accept full culpability for all of the mistakes. However, in progressing with my practice, I have looked back to the 25 years prior to the point where I became careless. And I believe that demonstrates what I'm capable of today. My clientele, I could have brought evidence from my clientele if I had thought about that, telling how I give them excellent care. And this is easy to do because I'm very good at it and I love the people and I have plenty of time. So I don't believe I have anything more to really add at this point. Thank you.
Mr. Tan, do you have questions you would like to ask of Mr. Showquist?
I do, Your Honor. Before I proceed, may we request the latest exhibits to be marked as respondents exhibits A and B?
Let's see, I have marked each of them numerically in order. So the first quarter evaluation is marked as Exhibit 7,
Okay, Your Honor.
and the fourth quarter is marked as Exhibit 8.
Thank you, Your Honor. I'll proceed accordingly. Good morning, Mr. Showquist. I understand that you encountered some issues today on the drive here.
Well, I got out of the hospital yesterday afternoon and then I got up at 4:30 this morning and came here and was here at 8:30, but at the wrong venue.
Of course, and we're not going to take that against you, sir. You mentioned earlier that you wanted to address the board regarding that fact, so I wanted to give you that.
That's okay.
Okay, moving on. My first question is with regards to your petition. I'm looking at AGO 39 of Exhibit 4. Just to clarify, with regards to your petition, you're seeking for an early termination of probation, correct?
Yes, I guess that's the case. It's strictly related to the expense of it. And since it costs me about $1,000 per month per quarter to employ the monitor.
Okay.
And so that's really my only reason. Looking at the record, the decision came down in December of 2012.
Mm-hmm.
And so that's almost, it'll be 6 years at the end of this year, I guess. And so then I have just one more year before the probation is no longer in effect. Is that true?
No, the decision was effective 2013, and
Okay.
you have a 7-year probation, so your probation terminates in 2020.
Yeah, I understand that, but I was wondering, once that period has left, that 7-year period, is that the end of the probation?
No.
Okay.
Yeah, the effective date. But let me ask the question.
Sure.
So with regards to the cost, do you intend to pay the cost in full?
Well, of course. I realize that it's a debt that's going to stay with me. So there is no other option, just since with the limited practice that I have and with the cost of the monitor, I was encouraged by the monitor to petition for early.
Termination.
Yeah, sure.
I see. Now, looking at your application, you do not have a letter of recommendation from the practice monitor. Is that correct?
Well, I believe that at the time in 2017, there was a special description sent forward to the board by the practice monitor. I did not see that, but I have every indication that it would reflect the success that she has observed in my quarterly reports and examinations.
Would it be a fair statement then to say that you did not seek a recommendation from your practice monitor?
Well, in truth, the practice monitor recommended that I apply for the.
But you did not seek a
Termination.
written recommendation from the practice monitor?
No, I did not. I'm not sure whether it came from the board or from me, but I was told by the board that that would be something that we should do. And so it was either recommended by me or the board, can't recall.
Would it be a fair statement as well to say that you do not have any letters of recommendation from colleagues,
No,
from customers?
no.
You mentioned the probation reports and your practice monitor reports. I'd like to direct your attention to Exhibit 4. Page 72.
I'm looking. Exhibit 472, yes.
On the bottom right portion, there's a base
Got it.
stamp, AGO, and
Got it.
there's a subsequent page number
I've got
on
it.
the bottom.
All right.
Tell me when you're there.
Sure.
So this is an email from your practice monitor stating that basically, and this was stated back in 2014, stating that, you were improving and the interim executive officer was congratulating you on your continued improvement and success with the practice monitoring program. But she does identify certain issues with your practice. Now, the reason I wanted to direct your attention to that is because as I review pages AGO 73 onwards up to the last probation or practice monitor quarterly report, she notes that you still lack or need some improvement on certain areas. I guess my question to you is, do you believe that well, first off, do you believe that the practice monitor was a benefit to you and your education and rehabilitation?
Absolutely. And I believe that maybe some of this inconsistency has to do with the clientele that I see, which in some cases were strictly for recommendations as to what they should do, conversation in the office with them that was indicated. And so if there was ever a problem with a client where they needed to have this, she would have indicated. But this is 2014 also, and the use of the SOAP notes is 100% at this point in time. The use of the quick stim test is with 100% in verifying the effects of amplification with all clients receiving hearing aids or repaired hearing aids. And verification measures are limited to the quick stim test and sound field testing when it's necessary.
Okay. So, moving on, I'm looking at the Exhibit 7, for example, and again, your practice monitor, and I represent to you that the practice monitor grades you as satisfactory from 2014 to 2018, but she does again cites issues. I'm looking at, for example, Exhibit 7. This is the April 12, 2018 practice monitoring report. She states that in this quarter, your files were professionally labeled, and you showed improvement in your SOAP notes, but there are still issues with regards to spell check of new purchase agreement, labeling of each files, create order in your records, review masking rules for conduction testing, and consider adding a tympanogram, Tympanogram, to test battery. So my question to you, Mr. Shokwas, is with regards to record keeping and also the air and bone conduction testing, which is the gist of the amended accusation back in 2013, it seems that these issues are still recurring. Why is that?
Well, I would say that the monitor is very, very good at what she does and is looking at everything that she sees in the practice very carefully.
So that the hearing is better.
Let's see if I can see that again. I think this is the one.
Yes. And just to clarify, both Exhibit 7 and 8 show issues with regards to reviewing masking rules for bone conduction testing. And it looks like the tympanogram testing was an issue in January and still is an issue by April 2018.
Yeah, well, yes, well, I have a tympanogram, and I am able to perform that test and have done it with clients very recently. When clients are receiving audiometric examination of pure tone testing, air and bone conduction, and speech audiometry, if there is evidence of any type of air-bone gap or any conductive component, then the client is referred for medical testing. The only time that I really need it in the future, I believe, is when the client needs further counseling with respect to getting medical attention and has indicated they're not interested. So to complete the examination that could go to a medical referral, that's important, and that's something we can do. We have a Grayson Stadler tympanometric machine, which I can employ when it's needed. Improved organizations of the files. This is really interesting, the labeling of the files. She indicated to me that she wanted me to get a printed label machine as opposed to printing it out. So I did do that. So that's the kind of recommendation that she's making. Review masking rule for bone conduction testing. If there was a profound hearing loss that did not, that we could not, due to the masking dilemma, we could not mask sufficiently. We discussed that, and she understood that it was not something that I could really present to the medical world as a conductive component because of the difficulty of doing masking in that situation. Let's see. Okay, I don't see anything else there. Thank you.
Well, after reviewing the practice monitor's quarterly reports from 2014 up to the present, and also reviewing the allegations in the amended accusations which you ascribe to, wouldn't you agree that the practice monitor would be a benefit to your practice at this point in time?
No, I don't believe that I need to have the practice monitor now because I believe that we have, with all clients in all conditions, have operated according to the rules of a hearing aid dispensing practice. I don't think there are any rules that have been broken for 5 years. Case in point, I have returned for credit one client's hearing device in the last 5 years. And that client had no hearing loss, but requested the opportunity to see what amplification would be like. But that's the only person that I have done a return for credit for.
Another case in point, on Exhibit 8, page 3, for client file number 3, one of the practice issues found was need for bone conduction testing on right ear and SRT and speech discrimination on the right ear. Wouldn't you agree that this is another issue that you've missed at this point?
Okay. Let's see.
It's your fourth order, it's the other one.
All right, I get it. Okay. So it's client number.
File number
File
3.
number. Okay.
Yes.
All right, that's good.
So there were some issues regarding bone conduction testing identified by your practice monitor.
Well, I guess that's a different one then, isn't it? Yes, that is, it's a different one. Must be this one here. Let's check it out. Need bone conduction at 504,000 hertz. This was, in my view, a minor procedural issue because the client came in to see if their hearing had changed and the air conduction, which was normal throughout except for the very high frequency and probably a 10 decibel drop at 500 hertz, was the same as the previous test. So I
Let me stop you there,
Yeah,
Mr. Shokos. I think you're talking about a different client. If you don't mind, let me point you to the right.
need to bone conduction test at 504,000.
So that's actually another issue. I'm actually referring to file number 3. This one right here.
Okay. This was, the date of this one was 2010. Okay, this is the previous one, the recent one. Number 8.
File number 3. Right here,
Oh,
sir.
3, okay, it's not number 8. That's it.
we're on Exhibit A. We previously marked your fourth quarter report as Exhibit A, but we're on file number 3, and it looks like your practice monitor has identified an issue with regards to bone conduction testing
Yeah.
on the right ear. Would you
This-
agree?
Absolutely, and this client, in the SOAP notes, it was written that the client refused any further testing. This was only a question, had their hearing changed? And so this was a procedural disagreement. It was not a matter of me overlooking the need for something.
I see. Same file, or I'm sorry, same exhibit, file number 5 on the next page. Your practice monitor identified the masking for the right ear was not performed correctly. Do you see that, sir?
Yeah.
Do you have an explanation?
No, I have no explanation for that. I don't know why she would say that.
Okay.
I don't know why she would say that. Unless there is a procedural gray area, that if there is a normal hearing threshold, is it necessary to do bone conduction with masking? And so I think I failed to put in the masking on that client, because there was no indication of further hearing loss, and it was a sharp dropping pure sensory neural hearing loss on the previous testing. So I can tell you, she is very, very, I wouldn't say fastidious, but she's excellent at what she does. She looks very carefully at every client. And I would say too, that in looking at these, that if there was ever a case where she felt that a client was not served properly, she would have asked me to recall the client.
Okay. Moving on, I'm going to ask the board to take a look at Exhibit 7. I'm on the 3rd page. I'm looking at file number 4. Mr. Showquist, tell me when you're there. So Exhibit 7 would be the other one.
Jeez.
Okay. Let me help you out here.
Yeah, it would be better if I did. Okay.
So I have the same question for you. Your practice monitor identified another issue where another customer needed mask bone conduction. Do you agree?
Absolutely, and on the first test, he did have masked bone conduction, and on the following test there was no change in the air conduction. The bone conduction was performed again without masking and showed the same test result as it did with masking previously, so it was a procedural decision.
Okay.
I don't use, well, go ahead.
You do agree that your practice monitor identified this as a practice issue, that the audiogram needs a masked bone conduction, correct?
Oh, sure, yeah. Yes, one of the things about audiology is that you may think you're doing everything absolutely perfect, but if someone comes without any other knowledge and looks at just the raw data, they're going to see, maybe you should have done this or this. But
On file number 6 on the next page, the practice monitor identifies another issue with regards to the audiogram not being listed in the SOAP notes. Do you agree?
could very well have been.
Okay. And wouldn't you agree that the audiogram would have to be part of the SOAP notes?
Have to is an interesting way of putting it, especially when the audiogram is attached to the SOAP notes.
But in this case, it wasn't, correct?
Of course
It says
it
that it
was.
wasn't. Did not see the audiogram listed in the SOAP notes.
Well, I think she's talking about me describing it in the SOAP notes.
I see.
It was attached, of course.
And on file number 8, she identifies another issue with masked bone conduction. Do you agree?
Yes, I could agree, I agree.
Okay. Now, after reviewing all the suggestions and the recommendations of your practice monitor, let me ask you again, do you believe that the practice monitor is a benefit to your practice currently?
Well, I think the practice monitor would be a benefit to every audiologist that is in practice. For someone to come and look with a magnifying glass would be helpful to every person. However, because of the overall picture and because of the satisfactory result of her monitoring for 5 years, is it now? Every quarter, I think that it's not a necessary thing that I do.
Do you agree that the areas identified by your practice monitor that need improvement, do you agree with those recommendations?
I agree with every recommendation. And if you would look at these results over a 5-year period, you'd see that there was a change from just about everything that she ever said in her report, that we tried to incorporate it into what I do.
I have nothing further, Your Honor.
Thank you. Now, as to the board members, each of you have an opportunity to ask questions, and how would you like? We can start. Yes. Mr. Shalet, do you have questions?
Yeah, a couple of issues here. At the beginning of your presentation, you stated the caseload that you have right now. So how many patients do you see?
I'd say 5 or 6 per week.
Because I'm looking at your petition and you wrote here that you see, where is this petition? I believe 20 a week.
Could be, but not now.
This was at the time that you wrote it, it was like less than a year ago.
Yeah. Now, describe for me, would you please, patient, that's anybody that comes in for batteries
Yeah.
or
Okay.
consultation, or someone who is seen for professional services.
Okay, the next question I have, it's maybe both to you and to the DAG. You stated in your petition that all clients were promptly paid the value set by the decision. So you return all the money to the people. Did you attach, or does the DAG or anybody has a proof of payment? Because you said here, see enclosure in brackets.
Yeah.
Do we have any proof that you paid it?
Yeah, good question, and they were paid, I believe, by cashier's check, and so I think I had copies that went forward to the board when
Do you have a copies?
If I
If
may,
you
sir, on Exhibit 5, we have the probation report. On AGO 104,
Where?
on Exhibit 5.
5, okay, at page 104?
Yes, yes,
Okay.
yes, sir. It would
Yeah.
be the last page of Exhibit 5. We have a
Wait.
report signed by Ms. Newman.
Which page?
104, it would be on the bottom right corner marked as AGO 104.
AGO, I have AGO 104. On which term? There's terms listed.
Yes, sir. On term 14,
Yeah,
under customer or consumer
Compliant.
institution, it states that Mr. Showquist is compliant for consumers for paid restitution
okay, so,
on January 7, 2014.
yeah, so I mean the probation monitor has a proof of the payments.
That is my understanding, sir, based
That
on
you
the
had.
signed document by Ms. Newman.
Okay. The last issue I want to ask is, when was the last time, first of all, did you ever supervise trainees to become hearing aid dispensers?
Yes.
When was the last time you
God.
supervised them?
I would believe it would be 1985 or something like that. I can't recall the exact date, but I had several offices.
1985. Okay. Thank you. No more further questions.
Was that 1985, you said?
Yeah, approximately, yeah. Environ 85.
Ms. Raggio, any questions?
Yes. You're a trained audiologist, yes? Okay. I guess I'm a little disturbed by the fact that you've had a practice monitor for 5 years who's presumably pointing out these issues, particularly having to do with mass bone conduction, that don't seem to be resolved. It still exists. That's still a problem with that. Your explanation that you gave on a couple of those cases, like there was a masking dilemma on a profound loss, which is incongruent to begin with.
Yeah.
One may not be able to do bone conduction testing because the audiometer doesn't reach levels in a profound loss in order to determine a threshold, but it isn't a masking dilemma.
Well, it could be if there was overmasking in the situation.
If it's a bilateral profound loss, that wouldn't never come up that way.
No, not if it's bilateral, symmetrical bilateral. No, you're right.
In any case, what we are trained to do is when we have to deviate from the standard of practice for an audiometric evaluation, we have to note that information at the bottom of the audiogram. If it's a masking dilemma, patient refused test, whatever it is,
Yeah.
we have to note that. We can't just blow it off and not say anything about it.
Good point.
And your monitor would have then not said anything had you, all of your explanations for not doing certain things, had you explained that, she wouldn't have had to say anything. The fact that she did says you don't have that practice down.
Well, I certainly think I do. If there's a masking dilemma, I will put that down. If there is a conductive component that's possible, I would indicate that too on the audiogram.
But I would think she would not have said something about lacking information if, bone conduction not done, had you had a reasonable explanation for why you didn't do it. So
Yeah.
that questions that. There's also the idea that, well, it looked this way last time, and so I didn't have to do it this time is not a very good argument because bone conduction changes as people age, even if you didn't have to do it in the past. I think not doing it is kind of an incomplete look.
Yeah, I agree with that. That the mastoid density could cause the bone conduction to be poorer. But so yes, I see the point.
You just need to do a complete job, whether you think it's necessary or not. This is a legal medical document, and you have to show it as such and not just something you're going to stick in your file and maybe look at next year.
Well, I'm not too old to learn, and I learn all the time, and I'm learning today.
Mhm.
So, yes, I agree with everything has to be as precise as possible and repeatable by somebody else. And so I understand that. In a hearing aid dispensing practice, when time is of a limitation and the issue is my hearing aid working properly, decisions can be made for expediency that might not look like full audiometric attention. But I see your point, and there's no defense for it.
Yeah, especially if it's still ongoing. I think that has to be remedied. Anyway, thank you.
Thank you.
Ms. Parker?
I would like to follow up on a comment you just made, in that you are learning even today. So that being the fact, would it not be valuable and important for you to continue having the practice monitor?
well, what could be the answer to it? I obviously don't feel that it's necessary at this point, and my monitor indicated she does not feel that it's necessary, and my monitor requested that I petition. So the two of us, although I really can't speak for her in her absence, but the document that she sent forward should, that I'm doing a very good job in attempting to avoid any of the problems in mistreating the public and record keeping and professionalism. For example, all my files now are of the same color. All of my clients' files are labeled with a large tape. All of the documents are freshly copied. So there's been a lot of improvement in that regard.
But I think I'm still concerned about Mrs. Raggio's comment regarding bone conduction and the audiograms. So, thank you.
Ms. Solomon Rice?
Yes, I have 2 points that I want to make. I think we're kind of beating a little bit of a dead horse here, but when I look at the most recent probation monitor or practice monitor reports, I'm really concerned about the relatively high percentage of client files reviewed that have comments for improvement, and that they're the same comments for improvement. When you say I can and always am learning, that's wonderful, but when you see the same area for improvement stated twice in a row, it seems like that's a pretty big red flag that I should be doing something about that. So how do you respond to the issue that 2 reports in a row discussed the lack of bone conduction testing, and a pretty high number of client files indicated you should have been doing bone conduction testing when you didn't do it? I mean, how much more information do you need to now implement bone conduction hearing? It's more of a statement than a question, but what is your intention in the area of bone conduction testing?
Well, I would be very bothered too if there was a high number. And so if a high number that I didn't do bone conduction with new clients or clients getting a follow-up exam, that's not possible. That's not something that I do not do. And if there is a client that does not require audiometrics, then maybe it would be a case that somebody should say, you should have done that, but that's just easy to say. Also, in my defense, to all of you, the monitor just can't give me an absolute rosy, perfect evaluation every time. It would not look like she is doing her job. So she becomes very punctilious. And if you would look at the documents that we have in question, you'd say, what? That's my defense.
Okay. The other comment that I have was brought up by the Deputy Attorney General about cost recovery, and the suggestion was that cost recovery be made before you can go off probation. What are your thoughts about that?
Well, my thoughts are that I did made application for this petition back in 2017, and I got a written evaluation that this was not possible because of the $4,700 that was still owed the state of California. So then I received a recommendation that I reapply. That's all I can say.
So your thoughts are that you shouldn't need to provide the cost recovery before receiving probation? Is that your thoughts?
No, but if you want to hear what's in my mind about all of this, I'll give it to you in about 30 seconds. This could be a very easy decision. You'd say, well, he hasn't paid the money. He has to continue with the monitor because he hasn't paid the state the money. On the other hand, it might be said that this person has complied for 5 years with the laws of the state of California in a satisfactory manner. And maybe some relief from the cost of monitoring could be put into the payment to the state. Now, I don't want to say that I am making anything other than a proposal in my own mind that that money that I pay could go to the state, and by the time I retire, could be all paid off. If it continues as it is, then I'm, with the limited practice I have, that will still be there when I finish. So I'm driving down the road, I'm thinking, yeah, maybe they should have a monitor once a year, or maybe every 6 months, and then it would give me a chance to catch up with the other part of the debt. So in your mind, in the board's mind, am I a danger to the world of audiology and to the clientele? And my monitor indicates I'm not, and I do not believe, in fact, I think I'm one of the best. So go ahead.
Okay, all right, thank you.
Ms. Snow?
Hi, good morning.
Hi.
I still am concerned with the monitor noting the same. It's pretty much the same as what other people have mentioned, the problem with the bone testing, and that just comes up a lot frequently, including the most recent ones. Have you talked to the monitor in depth about what she is catching, what's showing that, perhaps it's something in your notes that you're omitting to write? Have you talked to her more about why she continues to mention this issue?
Well, you're looking at how many documents there?
Well, it's mentioned in the latest two,
Okay.
and then
All
it's
right.
mentioned in several of the previous ones.
How many?
I'm sorry, I don't have an
Okay.
exact count, but
Okay. Well, my point is this, that those documents have been produced in the number of 20 now, and all of them have not indicated a problem with bone conduction, and if they had, she would have been much more, found it more problematic. And that this is something that may have occurred with a client that I have seen on a follow-up that I didn't think it was necessary to do any more medically related testing. And so she points out that she would have, but indicates that I am satisfactory in the way I'm producing this. And the guideline is, how is the public being served? How are they protected? Is somebody being damaged in any way because we differ sometimes in the way we do things? Anyway, that's my reply.
okay, thank you.
Thank you for your question.
Ms. Chang?
Hi, you mentioned that the monitor suggested that you apply for penalty relief, correct?
Excuse me?
You mentioned that the monitor suggested that you apply for penalty relief. Did you know that you could have asked your monitor for a statement before this hearing?
My assumption is that the statement was sent forward. I recall now that I did send down a document to her, or a note, saying that this is what the state wants, and I assume that she complied. That's all I can say about that, but
Okay.
all the while we're sitting here, I thought that you had in your possession her recommendation.
Do we
And I
have,
think before a decision is made on my behalf, that document that she should have sent or would have sent should be sent.
okay.
In other words, everybody should have that before they say,
Well, it's more like a recommendation to the board that
Absolutely.
Mr. Shoquist, has done everything and he
absolutely.
deserves to have. Okay.
Does that make sense to you, excuse me, that report from the monitor should be?
Let me interject here. This is the opportunity for board members to ask you questions
Okay,
rather than for you to ask the board members questions. And you will have an opportunity to share any additional information you have momentarily. Ms. Chang, do you have any other questions?
No, I'm done.
Does
thank you.
Ms. Solomon Rice?
So I did want to ask a question. So the board has received a binder, which the attorney, the deputy attorney general has gone over in great detail, the contents of this particular binder. Do you have the same information that we have in our binder?
Yes, if I may answer,
Yeah.
these are all identical binders.
Okay, so it should be quite possible for you to review all the information in the binders to see who did or did not write a recommendation for you, including your practice monitor. This information is available to you.
I don't understand.
You were saying you didn't know whether your practice monitor did or did not write a recommendation on your behalf, but you assumed that she or he did.
Yeah.
You have all the information that we have, so it's your responsibility to review the binder to see what information is or is not included. And for example, you brought to us 2 more quarterly evaluations with you because that information was not in the binder. So did you not review the contents of the binder to see what was or wasn't in the binder?
Well, in 2017, when I sent all the information forward, I sent all of the copies of the evaluation reports from the monitor that I had.
Right, no, that's not my question. My question is that you said you assumed your practice monitor had sent a recommendation to us
That's right.
stating the progress that you had made and why it was, why that person was in agreement that you go, that we shorten your probationary period of time. I'm saying, you have the same information we have. None of us have a recommendation from your practice monitor, including you. You have the same binder that we have. You could have, I'm not asking a question.
No, could I respond to it?
Yes, please.
Okay. The report from the monitor is a blind report. I do not see that. The reports that I get quarterly with respect to the practice notes, they are, I get copies of all that. But we're talking about a evaluation report of the entire picture coming from her to you. And I assumed that she had done this because she was directed to do so, but I would not get a copy of it.
Yes, you would, because you have the same binder that we have. You have all the
If I may
information.
interject,
Yeah,
Your Honor and members of the board, this is Mr. Shoquist's petition. It is his responsibility to provide the board any mitigating circumstances or evidence of rehabilitation. The assumption that the practice monitor would somehow read his mind and send out this recommendation is not true. We have quarterly reports. Whatever the board has in front of you, has it in front of them, is what the practice monitor submitted. They are not required to write a recommendation for Mr. Shoquist's petition. that would be something that he would have to go to his practice monitor and other colleagues and patients to obtain.
Right, and I guess my point is that you have the same information that we have, so it should be readily evident to you that you didn't have a recommendation from your practice
But
monitor
I've
or
only
anyone
had this-
else's.
I've only had this few minutes.
He didn't get it.
That's what I was, okay, so when did you okay, that's what I'm asking.
So again, if I may interject, the members of the board, the exhibit binder is nothing more than his application for penalty relief and the decision and a notice. Any other documents that he may or may not have submitted, including these documents that we have here today, Exhibit 7 and 8, he's already reviewed.
Yes, okay, that's my point, that you have exactly the same information that we have, so you would know what you did or did not send to us. We only have what you've given us.
I agree with that.
Yeah.
So my original question actually was, did you realize that you could have asked the monitor for a recommendation? Did you realize that, you could have asked your customers, hey, I'm having a hearing, can I have a recommendation from, did you realize that you could have done that, or you didn't know that you could do this extra stuff other than just providing these quarterly evaluations?
Yeah, very good question. That suggestion that I do that came from the person who was in charge of my probation here at the board. Then I sent that note to my practice monitor asking her to do that, and sent payment for doing it for me to her, because she has to be paid for everything she does. So I assume that the board had that, and if it doesn't, I'd like to know what happened to it, or did she not send it? It doesn't make sense because she's very, very organized. But she did receive payment and a request for that from me. I really wasn't remembering it very completely, but that's what happened. At the time when I sent all of these documents in, the person on this end was giving me direction as to what to send and so forth and how much, suggested I do that, or that she be instructed to do that, and so I did. And if that hasn't come forward, then it's either lost someplace, it would have been faxed, or she failed to do it, became inundated with her own practice. I don't know. But I think that these questions you're asking should be tabled until you see that report from her. That's only fair.
Any other questions from board members? Mr. Shalet?
Yes, Mr. Shukits. How many offices do you practice with? Do you have more than one office?
I have had 8.
You have 8 offices?
No, I have had 8. Then 7, 6, 5, 4, 3, 2, and 1 now.
Okay. Thank you.
Any other questions from board members? Mr. Tan, follow-up questions?
No follow-up questions.
Is there anything else you would like to say, Mr. Showquist?
No, it's just that last statement I made, I'd like to know if the board will agree that that would be valuable information to assess my decision.
This would be the time if there are no further questions, this would be the time we adjourn and go into closed session. So if there are no other questions or comments, this would be the time for us to go into closed session, and I will hand it over to Ms. Parker for that purpose.
Okay, so we'll just,
Want to go into-
yeah. Then we will now move into closed session. And make our decision.
Thank you.
Good afternoon. It is 12:30, and I'd like to call the meeting to order. First off, we'll do roll call.
Amnon Shalev, board member, hearing aid dispenser.
Marcia Raggio, audiologist, board member.
Dee Parker, speech language pathologist.
Patty Solomon Rice, speech language pathologist.
Debbie Snow, public member, board member.
Karen Chang, public member.
Although it's not required, if any members of the audience would like to give us their name at this time, please do so.
Brianne Humphrey, operations manager for the board. Linda Pippert, Cash, president-elect. Deanna McCoy, Chico Hearing Aid Center and candidate for the board. Carla Newman, board member. Board staff. Marnie Nielsen, practice audiologist. Christine Fromm, California Academy of Audiology president. Carolyn Bauer, audiologist.
Okay.
Martinez, board staff.
I want to say for the record too that Paul Sanchez, executive officer, and we also have with us our legal counsel, Kelsey Pruden.
Thank you. Are there any public comments or items for the agenda? They will not be acted on today, but this would be for use at a future time. Okay. In that, we will now go to, on our agenda, item number 9, which is an update from the Speech Language Pathology Practice Committee and possible action on any recommendations from the committee.
Why is the camera pointing at me? I'm still eating. Look at the camera.
It's not, it's fine.
Yes,
Yeah.
Carly, it's found. We can go up. I don't know. No. Yes, please.
So I will go, I'm Patty Solomon Rice, Chair of the SLP Practice Committee, and I'll go ahead and review the information from our Practice Committee meeting, which took place yesterday. So the topic of discussion had to do with telesupervision for supervisors of our speech language pathologists who are completing their required professional experience. So just for the audience, in case you're not aware, after an individual completes their master's degree, then they have a 9-month period of time full-time or an 18-month period of time part-time where they have a temporary license, which is known as the required professional experience temporary license. And at that point, they are to be supervised by a licensed speech language pathologist for 8 hours a month. So the issues of concern were, can the speech language pathology supervisor complete their supervision via telesupervision? In other words, not be physically present at the same location as the RPE with the temporary license. And in advance of this agendized meeting, and the reason for the agendized meeting, was because we've received some letters of concern from our licensed speech language pathologists. And the board, the practice committee had 3 letters that were received, and then there were some additional letters, I believe 5 additional letters that were received between when we received our board packet and when we actually had our meeting. And there were 2 issues of concern through those letters. One issue of concern was some confusion over the definition of direct supervision. And the confusion was, does direct supervision mean that the person has to be physically in person at the particular supervision event, or can the person not be physically in person but there at the same time? So real-time supervision but not physically in the same location as the temporary licensee. So that was one issue of concern. And then the second issue of concern is the whole idea of clarity about the ability to allow telesupervision for our RPE temporary licensees. In other words, we don't have any current regulations that address whether telesupervision can or cannot be provided for our temporary licensees. So those were the two issues of concern. We had discussion regarding both of those issues, and we felt that we needed to explore the issues more, so we did not come up with any particular conclusions other than what we want to do is work with legal counsel to I'll tell you what, we did come up with a couple of conclusions. One conclusion that we came up with is that when our speech language pathology assistants are supervised, the type of supervision they get, be it direct or indirect, is based on the activities that they are completing. So for example, if they are working with a medically fragile client, the speech language pathology supervisor has to physically be in the room with them. If they are completing tasks such as screening or some early treatment tasks during the beginning of their slip of supervision, the individual needs to be physically in the building but not necessarily in the room with that person. And then if they are completing a variety of other tasks such as clerical tasks, then there can be indirect supervision, which means the individual does not need to be physically in the building and does not need to be physically in the building or available in that way. So that's how our slip of supervision is organized, by the activity that's being completed. And so during our discussion, we decided that that would not be an appropriate way to organize supervision for our individuals with required professional experience temporary licenses. We felt that supervision should be based on the competency of the individual, that some RP temporary licensees are more competent than others in various and sundry areas. That's true for every profession. So we did decide that that should be the case, but above and beyond that, what we've decided to do is to work with our legal counsel, Kelsey, to determine how to develop language that would support the use of telesupervision based on the skills of our required professional experience licensee. And we might also explore that with SLPs as well. But at any rate, right now, we're really focusing on required professional experience. So we will be working with legal counsel between now and our meeting in August to develop some language. I think it's important to say that we are not opposed to telesupervision. And that we certainly understand that telesupervision is going to continue to increase in our field, not decrease. And so we want to figure out the most appropriate way to allow for telesupervision with our RPEs. And that's my report.
I just have a question. Are you concerned at all that you're leaving the notion of competency and skill up to the opinion of the supervisor, and that some people for expediency might see somebody more competent than they really are, or just that subjective feel to it seems a little scary, or could be.
And we are well aware of that, and that's why we want to work with Kelsey to develop some language that addresses those very issues.
Oh, is there any public comment on that report? Okay. Then we will move to item 10. And this is the discussion and possible action on audiology intraoperative monitoring.
Can I speak to that? At our last board meeting, there were a number of individuals who came to the meeting who practice intraoperative monitoring and wanted to discuss some of their frustrations with getting recognition not from the community itself, that is the professional community, but from insurance companies that they are indeed trained, and it is part of their scope of practice to do intraoperative monitoring. But when we looked at the language in statute, it doesn't kind of lay that out very, very clearly. But we did want to support, the board did want to support the notion that we recognize that it is part of the profession of audiology. So I was tasked with working with these individuals who are there to come up with a letter of support in a way that would address those issues. So I had already started a letter. I got a letter from one of our audience members here, and we kind of melded those two things. And then our executive officer and board counsel looked at that letter to see were there any issues that we were struggling with at all. And we kind of agreed eventually that we were okay with what it says. I then heard from Carolyn that, or from Dave Morledge, who was another person who was here, that he thought the particular language needed to be in there. I actually think it is in there already, mostly. But we still have a couple of questions. So we were hoping, Carolyn, you might come up and answer some things that were unclear to us. Since I don't do intraoperative monitoring, I'm not exactly sure how it works out there in the world. Is it a fact that you have to be licensed to do intraoperative monitoring?
So there are two different modes of intraoperative monitoring. There is no overall licensure required for intraoperative monitoring. There's no governing body. You can't receive a license in intraoperative monitoring through any organization. There are some board certifications that you can get. There are some certifications that you can get to become a technologist. There are two different models of intraoperative monitoring. There's a model where you have one person in the room doing both the technical, placing the electrodes on the patient, and also doing the professional component where you're interpreting the data. And then there's another model where you have a technologist in the room who is doing the technical component, placing the electrodes on the patient, communicating with the surgeon, and then you have a professional doing the professional part, an audiologist, a neurologist, a chiropractor who is interpreting the data in a remote location. So there are two different models of intraoperative monitoring, but there's no licensing governing body for the field as a whole.
Okay, so is it your experience or knowledge that a hospital can and will hire someone who might fall into, not an audiology with an audiology license per se, but just anybody who professes to have this skill?
A hospital may hire anyone who professes to have the skill for the technical portion. Typically, there's the requirement of that CNIM certification that's listed here to be a technologist, but a hospital has it within their purview to hire whoever they want to do the technical portion. For the interpretation of the data, that's typically done by someone with a doctoral level degree, either an audiologist or a MD.
I'm just, practically speaking, is it the hospital that pays for the services, or is it's insurance companies?
It's insurance companies
And so,
primarily. I mean, you can have a hospital contract where the hospital has decided to take care of all of that itself, and then they will bill the insurance company for your services, but it's kind of on a case-by-case basis. We have contracts with hospitals where we only bill the hospital, and we have contracts with hospitals where we provide the services and then bill the insurance company.
But you're thinking it's mostly insurance companies that you bill directly? Is that a fair
Right.
statement?
Right.
So if that's the case, how do insurance companies approach this notion that somebody can be, I assume even the person doing the technical part wants to be paid for that?
Right, and so you bill both the technical and the professional component. And so if you are billing the professional component, which is the area where the audiologists who are here at the last meeting are having the issues. They were saying that because they got that information from the DCA that we were not operating within our scope, they were not willing to pay us. So that was the problem, but it's not so much they're not looking for like a specific licensure. They just this one insurance company happened to ask.
But
The
these
wrong question.
people doing the technical work
Mm-hmm.
who don't necessarily have a degree or a license, insurance companies are willing to pay them. They find it in their scope of practice.
I don't know that there's I don't bill that way, so I can't speak to that.
I'm just
I don't-
curious if that's the
because
case.
I'm doing both the technical and the professional together since I'm an audiologist and have that doctoral degree, so I bill as a whole. So I'm not sure how that, as a technologist, how that insurance.
Might be something to inquire
Okay.
about among you.
I think that the majority of the audiologists who are here and most of the audiologists who are doing interoperative monitoring within the state of California are doing a global, where they're doing both the technical and the professional component. I would think that it would be a really small percentage of people who are just doing the professional.
I think we did write this letter and we're ready to supply you with that. There's still this somewhat discomfort with the notion that the language in this letter is not in the scope of practice per se, is not in statute. And there's still some confusion about it. So I think it would still be our recommendation that you perhaps wish to, as we talked about last time, seek a legislative solution
Okay.
to trying to address that.
Through CAA and with a lot of assistance from Amy White, who was unable to attend today, we've had some discussions with Sacramento advocates and the lobbying group, and their suggestion was to start with this letter and see how this was met by the insurance companies, and that if we were continuing to have problems with the insurance companies, that they would take it to the Insurance Board of California and discuss that with them. There was some concern about opening up the legislative to have this directly added to the scope, just because we may be met with opposition from some different groups. So should we try those things first, or should we continue with the legislative?
I think it has to fall to you to
Okay.
make that decision. Well, we do support this. I don't know about the, how to speak to the notion of.
Could
Do you
I
wanna say
just comment on the legislative part? It seems like we have two different issues here. One is, as I spoke about this at our last board meeting, someone asked a question of one of our board staff, and the question was posed about a specific definition within our scope of practice, and we answered the question correctly, but that was misconstrued as to say that you're restricted from practicing it. And in your case, even without legislation, you have qualifications and certification that you had to attain to do this, correct? So what we're recognizing in just kind of talking about this and occupational analysis is this is becoming part of something that's practiced within audiology. And that's something that I think hasn't been clear to lay people. What is the link between audiology and intraoperative monitoring? And there does seem to be a link, and maybe you guys can also talk about that. But if we are talking about changing, making statutory changes, then what that is saying is that you have to be an audiologist to do this.
Right.
But what I've seen from other states, and I know that there are at least I think a dozen states that have this within their practice act. Some are very specific, and some are not so specific and just talk about a type of testing. And I don't want to mess up the term. I think it's neural or something along those lines.
Right,
And then
neural
some say
function,
this may also include intraoperative monitoring.
Right.
Right.
I think that it's really important that we don't exclude any other groups who may do this. I think that that's where a lot of the fight would be. Obviously, there are neurologists who do this as every day, and so we would get a huge backlash from the AMA.
So I think we have
tried.
two different
Right.
tracks here, but I do agree with what Marcia says. This may be an issue that needs to be talked about specifically with that payee as to why they think you might be restricted from doing this when you are obviously, or the people that are doing this are certified to do this and have been reimbursed by other agencies and entities.
Yeah, and I think that's where a letter from you guys that would state that we are not restricted from doing this would help with the insurance companies in the shorthand. Okay, because if that letter we can submit, we can get a letter from you saying we are not restricted from doing this, then we can take that to the insurance companies, see if that solves the problem, and then, you know, hopefully we're okay. We might have to look at down the line, looking at adding something to scope of practice, but that's something that's gonna
And I
open
think
up a
that's
whole
why,
other ball of worms that we don't wanna.
and I think that's why we came up with the language that we came up with, because it's difficult to make a blanket statement like that when it requires a specific certification. But I think what we're saying is we just recognize that it's part of something that audiologists do. I don't know if you
And
wanna
part of it
comment on
is that interoperative monitoring grew out of audiology practices because we were doing tests that looked at neural function and things like that. So when initially interoperative monitoring started with, and correct me if I'm wrong because I don't know all of this, but with surgeries, if somebody came in for acoustic neuroma or some kind of a function with the brain, and they want to make sure that they're not hurting the nerves, they're not severing something, they're not causing another problem. And so because we have training and can obtain training on neural function, that we developed this through some of the other test equipment that we used with ABRs and stuff like that. So, you know, it kind of grew out of our department and historically, so that's how we ended up here. But the professional component can be done by a doctorate level profession, and we are one. So that's where we're not trying to limit other people from doing that for the professional component. We just we need something stating that, yes, we can do that so that the insurance companies don't shut them down.
And we did speak to that individual insurer and provide them with a huge amount of documentation that showed that we were well within our scope according to ASHA, AAA, our board certifications, our technical certifications to complete all of those tasks. And they misconstrued that statement by the board member or by the staff member and twisted it all around and just denied us based solely on that one statement. So.
I have a question. Right now, only medical doctors can charge for this?
No,
Who-
audiologists, chiropractors.
No, but you said they're restricting you because you are audiologist.
Right now, there are two major insurance companies that are restricting us, but I mean, we still.
These
pay-
two insurance companies,
Yes,
who can bill for this procedure and
Medical
get
doc-
payment?
medical doctors.
Medical doctor. Okay, so you want, yeah, so this is all about the money. The medical doctors wants to get their money and
I
not
think
you.
it's all about the insurance companies wanting,
Yeah, but-
not wanting to
Companies.
pay.
Okay,
Yeah.
it's all
Yeah.
about the money. Okay,
I mean,
thank
the
you.
insurance
It's more
companies-
political than professional.
Yes, the insurance companies come up with a variety of reasons not to pay.
Yeah.
Quite frequently, they'll say that it's experimental, that it hasn't been tested. That
Yeah,
I mean,
it's
and
the
we
same.
do thousands of
We
cases
live with
a
this
year,
all these
so-
years. A medical doctor can do hearing aids without a practical exam and nothing. Yeah.
Yeah.
It was always like
Does
this.
the doctor then turn around and pay the technician who does the practical?
It would depend on how they have that system set up.
Let's see.
So I know that there are practices that there may be a company of just technologists and they hire out the interpretation to an outside company that is medical doctors or audiologists. I'm not clear on how the billing works for all of that, but I can find out.
Okay, you had a chance to read the letter.
Yes, I did.
I don't know if you have any comments about its structure, what it states.
I think it's a good letter. I think it includes all of that information. I think that it covers the specific that Dr. Morledge was talking about with the different types of surgery. I would love to give it a try.
Okay.
See if it works.
Kelsey, did you want to say anything, or did you? No, I think that we can.
So I'm just a little confused about, so who wrote this letter? Did the board write this letter, or did CAA write this letter? Or who wrote this letter?
I wrote a draft
Okay.
and sent it to Marcia,
Right.
and then she already had a draft that she was working on, and so I think some pieces
Got it.
kind of melded.
And then we learned just recently
Right.
about the occupational analysis result
Okay.
and added, and Paul Sanchez was responsible for that, for pointing that out and including it in the letter.
So this was a really nice collaborative effort between board and association, which is wonderful.
And
So,
I had
thank
reached
you.
out to the members who attended at the last meeting
Mhm.
for assistance with our draft that we sent to you guys. So
That's great, thank you. So in other words, letterhead could include both letters, heads, the boards, or is this a letter coming from us?
I think
or-
it's coming from us,
Right.
although the notion was that they would help us, and they did with that. So the next step now, of course, is to put this on letterhead and sign it and actually send a formal letter.
is there any way that this can be a link on the website as well? That's something
I
that
think,
we
yeah, that's something that would make it easier if we could get a draft that's a link either on your website, and then that way we have your letter of support that we can forward and send to our CAA members and our audiologists that are having this issue.
I may have asked this question already, but who is this letter specifically going to?
You did ask that before, and I said, Who
Who is this letter going to?
To whom it may concern.
Yeah, I think that to whom it may concern is fine. I think that our
But we're trying to
our
address a
initial-
specific situation, right?
Well, I think that we will use this letter primarily for insurance companies, but I think that it's just a nice document to have. AAA and ASHA have similar documents on their website that are just a support document. So they're not necessarily addressed to anyone, but we do use those when we're developing contracts with hospitals or insurance companies. So we may not want to address it to a specific insurer. We may just want to leave it as a to whom it may concern.
Is there a difference between writing a letter to whom it may concern versus just a statement that is?
I think there is, and I don't see a problem with publishing something like that on our website, but I would like to reserve the right to talk to my legal
Okay.
counsel about it. And just kind of, for us to just consider.
Right.
All
No,
the factors.
absolutely. It's just, sometimes it's nice to,
And the
Yeah,
reason I
the-
say that it isn't because I have doubts about putting the letter out there, it's because we may want to explore more. There may be more, just in talking right now, kind of having a sidebar, we talked about some other things that may need to go into this letter.
okay.
So,
I doubt it.
This is a work in
I
progress.
doubt it.
yes.
Okay.
So when do we think that we'll have a final draft?
I think the letter, it sounds like the letter is good to go, right?
As far as
Yeah,
as
we've
I
already
know,
reviewed the letter.
yeah.
Okay.
So you guys
So-
are happy with the letter. And then, so what we need is to get the letter then on letterhead from you so that we can then,
We-
the different audiologists can submit it to the insurance companies to help them get paid. Because now
We're at a point now where
They're
we've
not
been
getting
denied
paid.
for so
Sure.
long that we're very close to not being able, our claims will expire because we haven't been able to get them any additional documentation, so.
Is this signed by you, Paul?
Well, that's why I was asking, if it's a letter, that doesn't take long for me to send it out. It doesn't require board approval. If we're
Okay.
talking about a position statement, then
Okay.
I think the board may want to discuss that
Okay.
more, but we can get a letter to you.
Okay, that would be great.
So do we have the
Are you?
correct address and all that, where to send it to?
Um,
Do we know that? I don't know if we know
You
it.
you can send me the information offline.
because we'll be publishing the letter then. We're okay to publish the letter that comes from you, right?
Yeah, this is a public document as far as I know. Let's get there.
Okay.
So if we're turning it into a position statement, that's when you have to,
Yeah, but I think for getting this done in a more expeditious manner, I can work on the letter.
Okay.
And I can work with your group, right?
Yeah.
great.
And you're okay with them distributing the letter then. I mean, it's a public
It's not-
document.
Right.
Thank you. Anything else?
No,
I want to ask one more question. I asked Marcia this, but I want to make sure about that we are correct in doing this letter. Is there any evidence that the medical doctors get more education in this specific area than doctor of audiology?
There's actually evidence that some of them get less.
Get less? Okay. Thank you.
Some of them.
Yeah.
But the board certifications that you can get in this, there is one that is specific to audiologists that is put up through ASHA, but there is also a board certification that audiologists can get and medical doctors can get, and it's through a different organization. And so audiologists and medical doctors go through the exact same set of requirements to receive that board certification.
In other words, there's no benefit that the doctor will perform this procedure than an audiologist.
Correct.
Correct.
do these technicians hold these same
A
certifications?
technician can't hold the board certification.
Interesting. Okay, we'll get that to you as soon as possible.
Great,
and
thank
hope
you
you're
so
happy with
much.
it.
Is there any other public comment? Okay, thank you.
Yes, I did. We're going to item number 12.
We're on-
Staff council is going to take over.
We are on item number 12, which is proposed regulations, discussion and possible action.
For item number 12, I'm going to have legal counsel start us off, give us a background.
As Patty mentioned earlier, we will be talking about SLIPAs. So the first regulation package that you have for your consideration is
It's right after my board report.
right after the board report. And it is related to speech-language pathology assistant application requirements for renewal, supervised clinical experience, required professional experience, and assistant training programs and requirements and qualifications for registrations. So some of this language the board has already approved, but much of it has not. So we're going to go through a little bit of it. And so we're going to start with 1399170, which are definitions. And again, as Patty primed for this discussion, SLIPAs are task-related, and there is direct supervision, indirect, and immediate. And so under C, subsection C, the board has already approved live electronic observation. The addition is real-time guidance. And I have a note that we should discuss whether or not this should be included or not. I included this language to make it a little bit more different than indirect supervision, to add a little bit, another level of what needs to be done and a little bit more guidance as to what is expected, so that it's not just live observation, it's also live guidance. So I don't know if that meets the board's needs, but that was my take on this particular part of language. So if there's no comments or
Is live real time?
so
Safe.
right. So we could add that language if you want to be abundantly clear. I think so. I think the board had already had live electronic observation, and that's what they had
Yeah,
added.
right.
maybe a couple years ago. So, but we haven't been able to get these regulations. So, or live real-time electronic observation. Or-
Live electronic observation and guidance.
Yeah.
Okay, and so just
do it
no,
that way.
and
Yes.
so no
Agree?
guidance,
Okay.
or no real-time.
Yes.
Yes,
because live
live,
is
real,
Okay, okay.
live electronic observation
And
and
guidance.
guidance.
And guidance, right.
Yeah. But I really, if I might comment, the addition of guidance is very important, so I
Right.
appreciate your
Yeah.
adding
Absolutely.
that to the regs.
I just, when I was reading it the first time, I looked and I thought, that doesn't seem that different than indirect supervision, so, okay.
No, thank you for that one.
So, and then in J of that subsection, the board had already approved qualifications deemed equivalent by the board meets a person who holds a license or a legal authorization to practice. It had additional language about the Practice Act, and Paul and I discussed and decided to remove that. It was a little bit, yeah, it was a little redundant. Yeah.
Okay.
So, moving on to 1399170.4, that has not changed at all from what the board last approved. So 170.10, at a previous meeting, the board had motioned and moved to update the speech language pathology assistant ASHA documents. One had come out in 2013, so around a little bit around that time, the board had decided, oh, there's a new document we should update. However, when I went to look at that document, it did not have any competencies or any sort of structure for the coursework that should be included in the SLIPA program. So therefore, the old 1996 version does, and so that's what's currently incorporated by reference, that's what's currently enforced. I included both of those documents in your packet for you to review. But it's my understanding that, and maybe Patty, you can speak to this, that in the future it might be updated again. But as it is right now, perhaps leaving the 1996 version is the best option for the board.
Right, so just to add to what Kelsey is saying, the American Speech Language Hearing Association is currently developing a certification program for SLIPAs. And in the process of developing a certification program for SLIPAs, they will need to identify curriculum that meets the needs of the scope of practice for SLIPAs. But that is probably not going to come out for peer review, et cetera, for at least another year. And so we're just in a predicament that we really can't wait on this anymore. So the best information we have from now is unfortunately from 1996. And that's just all there is to it. And that's what we can go with now, but we will need to change this as soon as that additional curricular information comes out.
And that can be done exactly at a later time. We have left that 1996 version. The board already voted on and approved changing it to 100 clock hours, again to be more consistent with the ASHA guidelines. And the same is true for 170.11. Again, B, that 100 hours of fieldwork experience. And then the board has already approved the change of 36 weeks versus 9 months as being the definition of full-time. So a new addition, though, is subsection B2. And it says, in addition to completion of the bachelor's degree program, completion of a 3-unit semester or 4-unit for quarter, course specific to speech-language pathology assistants, the scope of practice for speech-language pathology assistants, and the California laws and regulations that govern speech-language pathology assistants. And the reason behind that is that your statute allows for an equivalent course of study in order to be licensed as a SLPA. And under that statute, it defines one of the equivalent courses of study as a bachelor's degree in communicative disorders or, oh, I'm blanking on the other one. Speech-language pathology. I don't know how I blanked on that one, but. However, if they've completed that bachelor's degree, they may not have had a class that is specific to being a SLPA. So this adds that requirement in addition to that bachelor's degree.
And I might add that we found it very important to include this information because there have been so many concerns about the scope of practice of SLPAs, and we want to be very clear about what the legalities are and really emphasize. I think many bachelor's programs already have this included in their SLPA training, but nonetheless, we wanted in our regulations to ensure that all bachelor's degree programs that are incorporating a SLPA piece also have them complete this course.
Absolutely. Okay. So now we're going to get to the really fun part. Everybody buckle up. 1399170.13. So I worked very closely with Brianne and Katrina and your licensing crew, your licensing staff, to develop some applications and forms that need to be completed for verification and licensure. So then this is all new, just so you know. So let's turn to the SPA 100 version 2018.
So at this point, you may want to separate the section after the text that starts with application checklist and maybe pull those off to the side because you'll be referring to both. So there's a page that actually has a graphic of a checklist on it and has a little box that says application checklist. That's it.
So it looks like this.
Oh, you have tabs. Amnon has a better binder than I do.
Okay, that is
Okay.
the sign.
Yes, so this is a document that will be incorporated by reference. So that means that it holds the same effect as your regulation text. It's just a separate document that we're not putting in text because it would be too cumbersome to do so. So this is what all speech-language pathology assistants will be required to fill out and send to the board for application. It requires them to complete the entire application and submit a passport quality photo, pay the fees, include a course catalog or program syllabi with full descriptions of the coursework taken so that your staff can verify, especially for the equivalent programs, that all of that curriculum has been met. A photocopy of diploma, unless it's posted on transcripts or evidence of completion of a bachelor's degree, again, for that equivalent coursework. A verification form, and this has to do with the type of field work or employment work experience that you have received with your training. And so that will be specific to that individual's background. And then fingerprints and the supervisor responsibility statement, which we'll get to all of those in a minute. So if you just want to take a look at the application, it has your general asks for name, all your address of record. It asks about where you completed your educational experience and when you got / what type of degree. It has the questions about convictions and discipline for discipline purposes. Absolutely.
So for the email address, because I want to make Amnon happy, the email address is optional. Is that legal that we have to say optional after email?
We don't have a statute that requires,
Oh, that's what it is.
yes.
Oh,
So we leave it optional.
okay, thank you.
Yes. You have a statute that requires the address of record, that they have to provide their name, those types of things. Any other questions on the application?
I think it looks fantastic. And thank you, everybody, for,
It was
it's, to me, it's a
group effort.
user-friendly. To me, it's a user-friendly application. Yeah.
Okay, so now let's go to the verification forms, because those are also going to be a part of this application process. So again, under the education and qualifications that we just talked about, there is a fieldwork / clinical coursework / employment work experience aspect or component to being eligible to be licensed as a speech-language pathology assistant. So the first one is the fieldwork experience verification form for a board-approved speech-language pathology assistant program. So it's a board-approved SLPA program, so they've already looked at that, the board's already approved that fieldwork component, but it just has the supervisor's name, location where it was experienced. The major difference for this now is that it's not submitted necessarily by the applicant. It is submitted by the educational institution. So the signatures on there need to be from the training program director or coordinator, and also the fieldwork program director or coordinator, so that the board can actually verify that it came from the institution and what experience has been done there. So previously, the board had looked at ones where it was submitted by the individual, but they had to go get a signature from somebody verifying, and that was one of the issues we had with the not the application, but the supervisor's responsibility statement last time. OAL pointed out to us that it's really unclear who should be filling this out. It's really unclear who's responsible to submit it. So I went ahead and made it so that it's coming from the institution. If the board feels a different way, if the board wants the student to submit it, please let me know. But I did look at what other boards did, and it was consistent.
Absolutely love it, because that's consistent with graduation from master's programs as well. Now we have consistency between master's, bachelor's, and AA programs. I think it makes perfect sense.
Yes.
This is probably for Patty. When it says name of current training program director, signature, and then fieldwork program director,
Is the director, is the training program director and the field worker, are they all from the school? Or can the field director be from, I don't know, private organization? Because if that's the case, then the student would have to take it to the training director and then also take it to the field director too, right?
They're both from universities. They might be the same person, they might not be the same person.
Okay, and then so with this, so I'm imagining myself as a student, and then I have to get this filled out. So do I take two of these and just give it to them, or do I take one sheet and have one sign it, and then you grab it, and then take another sheet and have another person sign? You know what I'm saying? I don't know. Is that confusing? Am I being confusing?
Well, so the instructions say that this form must be completed by the speech-language pathology assistant program where the field work was obtained. So my understanding, and again, correct me if I'm wrong, I know that some institutions do contract out, but it's still within the program. Is that right?
Well, they would have a memorandum of understanding with that
Yeah.
particular fieldwork coordinator. So there would be a contract with the community college and the fieldwork provider.
So the community, so I do agree with what you're saying.
Yeah, I don't know
I
if
do
I'm-
understand it, so I want to make sure, because I haven't gone through this experience, so.
Staff clarification. Want to ask Katrina? She knows.
Oh, yeah, let me finish my thought. If the student brought this to their,
Program director.
program director, would the program director have the authority or have the ability to say to the fieldwork experience
Yeah.
coordinator, you need to sign this?
It would be a requirement of the university for obtaining the degree. So ultimately, it's the program director's job to do that.
So, should it be maybe just the program director? Because I know that the verification in the regulation now, I even have slip a tab, look. It says, and we can change this, we have this regulation open, but it says, where is it? Yeah. Maybe. Yeah. Maybe it's in the statute. I know that I pulled the actual training program director coordinator from something.
There's certainly precedent in our university, for example, if a student wants to petition to change a grade or add or drop a class, the instructor has to sign that form. It has to be taken to the chair to be signed, then it goes to the dean to be signed. It's all the same form.
Yeah.
And sometimes the student literally has to march that to each office, and other times
Yeah.
our office manager will simply pass it along on their behalf. But it's not uncommon to have
Right.
multiple signatures on a
I mean,
form.
our job is not to make this super easy for the student in lieu of the accurate
Right.
verification by the instructors. So, I mean, my feeling is that if they have to run around, they have to run around. That's life. We want to make it as easy as possible, but our end goal is not to make it as easy as
Right, no, no, no.
possible. Our end goal is to make sure the requirements are met.
Actually, as associate dean, I'm dealing with this type of thing all the time. And at our university, and I think others as well, they'll bring it into the dean's office at this level, and then we follow through with the signatures.
So you
So the
guys,
students
are the ones that follow through with the signatures.
Yeah.
Okay. I was just curious, like, when I think of field work, I think of going out into the field and doing it and then getting its signature from the manager that was out in the field.
So some of the other forms do follow more of that
Uh-huh.
because that's more akin to that type of experience, like the work experience, for example.
Right.
But my understanding is that this would be feasible and would probably be, because it's part of the curriculum.
Okay.
Is that an accurate statement?
Right, and also, I don't know if you're confusing this or not, but this is not the fieldwork supervisor who's signing this. This is the fieldwork director. Those are two
Okay.
different people.
Okay.
University-based.
It's the university
University-based.
person
Okay,
who's
okay.
signing
Right,
it,
okay.
verifying that the fieldwork was completed in X location and 100 hours were completed.
Okay.
So it's not that supervisor.
Right,
It's
right.
it's the university fieldwork.
Right.
Okay.
And the university is then putting in what the supervisor's name is and all of that, but verifying. And you do have a reg, it's 1399170.6 that says the program director of the sponsoring institution shall be responsible for ensuring that the scope of responsibilities delegated to students during fieldwork experiences are appropriate to the training received and the clients assigned, et cetera. So that's, I think, where I pulled that.
Okay.
But
I think that's what you were confusing. You were thinking that it was the actual person supervising who needs to sign it. No. They do have to sign some forms, but they sign them, give them to the student brings them to the university, and these folks verify that it was in fact completed.
Okay, all right. And actually, students are given the information ahead of time, so they're not making a separate drive out there, once again, to get that signature.
Okay.
It's ordered very carefully.
Okay. So the next one is the fieldwork experience verification form for completion of a bachelor's degree. And very similar, with the exception that it's just the signature of the current training program director, because that's currently what the regulation requires, is that it must be verified by that person, and in the event that it's not, that person can, the applicant can appeal. Now, if the board chooses to add that additional requirement of the 3 or 4 unit course specific to SLPA, I will need to update probably the application or one of these forms to reflect that verification.
It is important.
So I just, it probably will go best on the application portion of it, just to say you need to submit
That too.
that evidence of completion of that particular course. So I do want to call attention to that while I'm thinking about it.
Yeah.
Okay, so back to the fieldwork experience verification form. That, it says that the fieldwork experience shall be evaluated for verification by the current training program director. So that's why that person's signature is the only one on this particular form. And then here we have the next one is the employment work experience verification form for completion of a bachelor's degree. So in lieu of a fieldwork experience, it's full-time work experience. And that that has more of the employer HR stuff. I do have a question on the board's original form. It says if this employer's name and address, and it has an asterisk, if this is a non-public agency or non-public school, you must attach verification, and I'm not sure what that verification would be.
I think Brianne needs to answer that.
Linda?
I think I may know, because if you're a non-public agent, oh, yes.
Linda Pippert, and I work for a company that is a non-public agency. And so frequently, we're asked to provide the sheet that's sent out to us, the certification from the Department of Education showing that we are indeed a non-public agency.
Okay.
And so
Okay.
that's very common in our contracts. So I don't think it would throw anyone that worked for a non-public agency. They would know immediately what you were asking for.
Okay. Just for purposes of getting the regulation through OAL, we need to be really clear.
Sure.
So it's a Department of Education certification?
No.
It comes from the Department of Ed, and I don't have a copy of the exact title of the form, but I'll search to find that and send it to you.
Okay, that'd be very helpful.
Yeah.
Is what we're wanting is the non-public agency number? Is that what we want?
Yes, but
Yeah.
there's a face sheet letter they sent back to the non-public
Okay.
agency saying, from the California Department of Education, here's your approved number, yeah.
Okay,
But the specific title of the form, I'm sorry, is escaping me at the moment.
thank you. Okay,
Okay.
so just so the board knows, with that updated information, I will update this form to make it very clear what it is. So it asks for the responsible supervisor's license or credential. And then it asks for the duties performed by the applicant, because part of the work experience, it has to be full-time doing SLPA duties. So this gives your board staff the ability to verify that SLPA duties as enumerated in your statute have been completed for the requisite amount of time. And again, filled out by the HR department and the responsible supervisor. So that's more, I think, what you're envisioning. And the last one is from an equivalent. It's for a field work experience from an equivalent speech language pathology assistant program. And my understanding is that it might be out of state or something like that. So again, it's a certification coming from the training program director and the fieldwork program director. Okay, so going back to the language now, thank you for getting through that with me.
Can we just applaud you for creating these forms, which.
I had a
again,
lot of help. But I don't know that I want to hear the term SLIPA ever again. I'm just kidding.
Unfortunately, you will.
I know, unfortunately, I did. I wrote an email to Paul and said that, and then the very next email I sent was, and about the SLIPAs.
We're gonna have to give her an honorary SLIPA registration.
Okay, so 170.13, they just incorporate all that application and those 4 forms by reference and require the individual to submit them to the board. So 170.14, the only thing that's happened is that we've taken out the fee because we put that in the fee reg. So it should be taken care of there. Now we're going to go to 170.15, and this is the supervisor. And this is where we had some issues from OAL. What I noticed about the board's supervisor statement was that most of it was already in the regulation. So if it's put into the regulation, then the board does not have to incorporate the actual form by reference because everything on the form will already be in regulation. So it's already enforceable. So what I did was I updated a few things. I made some clarifications, 30 business days rather than just 30 days so that they know that it's business days and not calendar. And that's in subsection B. And then what I did is I just reformatted verbiage that was already there to require what is on the form. So we need to have the name and number and license number, their address of record, a statement as to whether the speech language pathology assistant has more than one supervisor, and if so, if the supervisor submitting the form is the lead supervisor, because you have a different regulation on that. And then a statement that's affirming that the supervisor shall do all of the following. And the one thing, and the board had already approved this, but I just want to call attention is that the board added 2 years of experience prior to supervising SLIPAs. And that the board had already approved during the first 90 days, the supervisor shall provide immediate supervision at least 20% of the week of the work schedule.
Do we want to add at least 2 years of full-time experience as a licensed speech and language pathologist? Because 2 years full-time experience could be a RPE year and 1 year.
Okay, so services as a licensed speech language pathologist rather than
Yes.
just as a speech language pathologist.
Yes.
Okay.
Yes.
Again, so all of this was already there. The underlining, most of it is I just had to change some words around to make it more of a statement. The things that I did add start at K. Provide a copy of the form to the assistant within 45 business days. From the commencement date of supervision. I added 45 business days. I don't know what the board's, how the board feels about that. the board currently requires the form to be submitted from the supervisor to the board within 30 days of commencement of supervision. So I had added additional 15 days to get the copy of it to the SLIPA. I did, I crossed it out. Sorry, I did make a comment that it's from, not of from. My typo, yes. Thank you, Dee. So I don't, is the board comfortable with that additional 15 days from the time that it needs to be to the board? And then not supervise more than 3 support personnel, which again, that's already in a regulation that you have, but it needs to be part of the acknowledgement, and assume responsibility for all services provided to the clients by the speech language pathology assistant that is being supervised. And the rest is not new at all. So this saves the board a little bit of time in terms of the form, but everything that's on the form is already in regulation. So those are the SLIPAs regulations.
So you'll remember to add to item 5A as a licensed speech and language pathologist.
Yes, I've made notes. There's a few places where I'm going to make a couple changes.
Okay.
So if the board is content with that, we could have a motion to notice them.
I move to notice.
Okay, and perhaps to delegate to the executive officer the ability to make any non-substantial changes to the rulemaking.
And with what Kelsey just said.
Okay.
Is there a second?
Second.
Okay, then we'll call for the vote.
Oh, any public comment?
Oh, any public comment?
Yeah.
No. Okay.
Yes.
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 Yes. Yes.
Yes.
And thank you.
Oh my gosh, thank you so much.
I learned a lot. Okay, DGs, you want to take that one? You want to take that one? Huh? Let me open my.
You can explain to everyone why we're doing this. The
Okay.
next item we're going to look at is the disciplinary guidelines
Yes.
booklet.
Use your microphone.
Oh, I'm sorry. The next item on the agenda is, we're going to look at the disciplinary guidelines booklet, and that's agenda item 12C, CCR section 1399.131 and 155, which references the disciplinary guidelines. You may be wondering why we are looking at this again, and this has been something that we have been working on. Our current disciplinary guidelines are 2 documents. One for hearing aid dispensers that I believe is 1998, and the speech language pathology audiology side would be 2004. I'm sure I got those dates right. We need to update our guidelines, and we actually worked very hard. It's 1997 for hearing aid dispensers, and it's 2004 for speech language pathology. We actually worked very hard several meetings ago, spent a lot of time on this, and I think where we were having problems is looking at the various versions and trying to put together a document that is acceptable for the Office of Administrative Law to approve. Kelsey, again, has really helped us here because we don't have a designated legislative regulatory analyst. So she's really gone above and beyond and helped us in this area, just like she did with speech language pathology assistant regs. So what we tried to do here is present the whole document to you so it's less confusing, and then maybe just highlight the areas that are new or that have changed. And I don't think there are a whole lot of changes. I think most of this is really formatting.
Yes, so the biggest thing, and again, because I am assisting with this, I sort of made an executive decision. Originally, we were merging the two and trying to use one version, and so the Office of Administrative Law requires that with your notice of the proposed text that you underline all new text and strike through all text that you are deleting. So, or it doesn't actually use that verbiage, but you just have to make it abundantly clear to the public what changes you're making. So most boards opt to do it by underline and strike through. That is not my strong point. So I was having a very hard time making sure that the old text from this version was strike through, and so what has been done is just now it's just one new document. The consequences of that is that in an initial statement of reasons, you have to give the reason behind why you're making the changes, and so now we'll have to justify all of it. But your disciplinary guidelines were so different from your original ones that we were going to have to do that anyway. So I didn't see it as a deterrent from doing so. So that's just a formatting thing. And then I added, so the only new thing, the first new thing starts on the 5th page. Right, okay. So this is model language that is used by ALJs and when in stipulated decisions. So boards generally give guidelines as to what they want to see a decision look like. So these are model disciplinary orders and conditions. So these are the way that they should be written in your proposed decision or in your stipulated agreement. And so I just added a few things, and I took out, we had brackets that just says, insert license name or number. So I kept that consistent. So the ALJ or the DAG can just insert that. I added an applicant granted with probation. Just added some verbiage to that. It is hereby ordered that upon successful completion of all licensing requirements, respondent name shall be issued a license or registration as license type or registration type. The license shall immediately be revoked. However, the revocation will be stayed and respondent placed on probation for a period of years following the terms and conditions. I added language about surrendering of license. Sometimes respondents will surrender their license, not in lieu of discipline because it still can be considered discipline, but will surrender instead of going through the hearing process or entering into a stipulated agreement. So it's really important to have language in there that maps out what happens if they want to petition the board to come back and get their license back. So Paul and I discussed this aspect of it. Some boards make it that a clear surrender and then you must reapply, do a completely new application and meet all of the educational requirements and examination requirements at that time. Okay. Yes. But some boards also do it as a petition for reinstatement of licensure, in which case that person must come before the board and tell the board why they deserve to get their license back. So the way that the board approved it and the way that it's written is a reapplication, or not a reapplication, I'm sorry, a petition. And then I added just public approval, since that is one of the forms of discipline that can occur, just so that we're consistent and we're thorough and we have all of the different scenarios that could happen in a disciplinary proceeding. So we have language for it. I added a reinstatement option for condition precedent for taking and passing the current examination if the board sometimes the board would like the person to do that before they can be reinstated. And cost recovery, also very important language to have, that if the person wants to petition, they must pay cost recovery. The next place that we, again, the standard terms and probation, not a lot changed here. Number 11, 10 and 11, I believe I merged together. The second one, obey all laws. The original language had military laws. It had all of these additional
What page are
laws
you
in it. Oh, I'm sorry. This is page 8. So I just simplified it to federal, state, and local laws. Not everybody is required to follow military law. So, but essentially, you have all your bases covered with this language. You don't need the additional language. And it was just confusing. So,
Why was if it was confusing, why was military law in there in the first place?
it was at the suggestion of the previous enforcement coordinator. I think she had maybe had some issues. I don't recall, but she wanted wanted things to be very specific. I think that she had some issues prior. But guidelines again should be specific enough, but they're guidelines, right? They don't always apply. But it was just it was confusing because if you're not in the military, then the military law shouldn't apply to you. But it wasn't written that way.
Okay.
So yeah, it was just. So number 3, I merged 2 into 1. So it was comply with probation program, and then you had a separate one that said cooperate with board staff. I think that they're all kind of the same idea. So I just merged the 2. Added things like calendar days rather than just days to make it clear.
And this is something that I think we'll just have to point out. Sometimes probationers don't understand that they actually have to come and meet with board staff. In the past, well, I think in the distant past, they would just get a letter that would tell them, the board reached this decision, here are your probationary terms, and then it was a phone call. The board reached this decision, here are your probationary terms, let me go over them with you. And now, the rationale is we go through all this work, all this, thought, a lot of people involved in disciplining a license, and we want to make sure that we sit down with that probationer and go over all this information with them and make sure that we're on the same page. So that's why we let them know that they have to travel possibly to Sacramento to meet with us, and we'll have to emphasize that. I think that's why it was separated before, but I don't see a need to have a separate item.
Okay. The next one, and I made some feedback on this one. It's number 6, the notice to employers. I added language about being contracted to provide services because it's my understanding that sometimes certain license holders use like a temp service or to do that. So, and I know that we had in the past a petitioner,
Right.
and the board was concerned that she hadn't given the temp agency the notice of decision. So I included that language, remembering the board having some concern about that. So if it doesn't fit, please let me know.
What specific language if contracted?
Yeah,
The
if
section
contracted
says
to provide
contracted,
services
okay.
that require a license, respondent shall notify contractor of probationary status of license.
is there a better word for contractor? If contracted, so you're contracted by an agency, right? Respondent shall notify, should it be agency or is contractor?
I don't know, I'm not.
Would it be client?
So instead of notifying the
Contractors.
agency, notifying the client that you're working, that they place you with?
Well, I think in this case, the reason this came up is, this has actually come up more than once. You all witnessed it in a petition, but where a probationer says, well, I don't have an employer. I'm independently employed, but you're actually employed by an agency who is sending you out, and that agency doesn't know that you have been disciplined by the board. And there was this kind of word game going on. So I think we wanted to make sure that we covered it. And I think Kelsey wisely put it in there. I just want to make sure that if we're saying respondent shall notify the contractor, that that's the right term, and or is it agency?
Contracting agency.
Thank you. Thank you, Linda Pepper. So Linda said contracting agency, is that, okay.
Or what if they're an independent contractor and they have their own business and then they just go, like a client goes to them?
Yeah, so it as it's written now, it's just notice to employers. It's not notice to the patients. But okay, so changing that to and I'll do it throughout, but contracting agency, right? Contracting agency. Notice to employees, the next one, I just added calendar days. And again, throughout the document, I inserted calendar or business days depending on the situation. So I'll point that out. Interviews with board representatives was next, but I moved that. Cost recovery, I made that 30 calendar days. That's the only change there. No real changes to probation monitoring costs or maintaining a valid license. Number 11, I merged that. Previously, you had it where one was in California and one was out of California. In my opinion, for purposes of tolling, it doesn't matter where you're residing. If you're not practicing, then you're tolling. So it merged the two. And I will say, we'll get to that. The board, and then the board had already decided that tolling for either consecutive or inconsecutively for 36 months was a violation of probation. Mm-hmm. Yes.
Is it a fixed amount or certain, each case has its own different cost secured by the board?
Right now, it's a fixed amount.
Fixed amount?
Yes.
And the board issued the guide for patient an invoice every, quarter or something?
Yeah, yes, at the,
Issue an invoice?
during the interview process, the probationers are given information along with a checklist, and they're given a specific payment plan if that's required. In some cases, they pay the costs up front, and they're given an option to submit a payment with their quarterly report by a certain date of the month of that quarter.
How much is it? How much right now?
I want to make sure I get this right. Maybe Carla could help me. I believe it's right now at a minimum amount. It's like $1,000 a year. Is that correct, Carla? The question was, what is the current cost for probation monitoring?
$300 a month?
Yeah.
200?
Yeah.
Is it $200 a month?
Yes, probation monitoring is $200 per month.
Thank you.
The next term is voluntary license surrender. That's been changed as voluntary license surrender. Again, very important that if you have somebody who is on probation and decides that they want to surrender their license, that you have some verbiage that includes that if they want to come back to the board or come back and be licensed, they need to pay their cost recovery, and as well as they may not apply for a license within 3 years from the effective date of the decision.
Just have a clarification on the monitoring cost.
I apologize, I said $200 per month, that's $200 per quarter. They pay quarterly,
Okay.
so $1,200.
And so it's $1,200 a year?
No.
No,
$200 a month, $800 a year?
Yes.
Is that correct? Okay. And
It's
I said a month too,
quarters,
so
yeah.
I was just trying to see if you were,
3 quarters, $200.
okay, okay.
I apologize, it's been a
Okay.
long day.
And that has not been reevaluated recently, so I think that's something that we'll probably look at again, yeah.
Okay, and that does it for what the board hasn't seen and approved for the standard terms. Now we go to optional terms and probation. In the first one, educational course, I just did 60 calendar days to make it abundantly clear. And then it's 5 business days for the next part. Consumer restitution, again, adding calendar days. 17 is the same. Although it is at the very last sentence, 1 business day. So if there is a evaluation by a physician, that physician needs to provide. They need to provide the physician's. If the physician says that they cannot continue to practice safely, the board needs to be notified within 1 business day.
And that is number 18 on the board materials.
Oh, okay, sorry.
That's good.
I'm going off of my track changes copy. Okay.
Kelsey, just for clarification, I think your numbering is just one off because we separated the out-of-state tolling again, and I think that may be.
Okay.
So,
Okay, sorry.
that's okay. Just wanted to point that out.
So the next one that has changes is serving as a supervisor, which is 21, maybe?
Yeah, that's right now.
I just added or licensed assistant, since an assistant can be licensed. Or trainee can be licensed, I'm sorry.
Page 18, number 22, serving as supervisor.
And then restrictions on licensed practice, again, calendar days added. Same for practice billing monitor. For take and pass licensure examination, that's the next one that has any changes. And that is page 21, number 26. It just has various options. One is a condition precedent and one is not. Is the clinical diagnostic evaluation the same?
Yeah.
Okay. Clinical diagnostic evaluation. Again, that adds one of the options is that they have to do that before the stay of the revocation. So before anything becomes effective, they need to do the clinical diagnostic evaluation. And then the other is just that they have to submit to a clinical diagnostic evaluation. The language is pretty similar to what has already been approved. The next one that changed is abstain from drugs and alcohol and submit to drug and alcohol testing. And the one thing that I did not have time to look into to research was whether or not marijuana should be specifically named as something that needs to be abstained from, considering the status in California versus the status legally versus or federally, and whether or not it should just be called out like alcohol is. So if the board thinks that it should, I can still look into it, but we can insert it in now in order to make it clear.
And the thought behind that is that if the classification of marijuana changes, right, and we just put what the classification is, then the probationer would be allowed to use marijuana. When you're dealing with a drug abusing licensee or a licensee who's an addict, you don't want them to be using mind altering substances, and marijuana would be a mind altering substance, just like alcohol. Even if the offense has to do with drugs, you still want to restrict them from alcohol, and if the offense has to do with alcohol, you still want to restrict them from drugs.
The next one is biological.
Oh, wait, so are we going to ask to put marijuana in right now, or?
That's in the proposed language right now,
Okay.
marijuana.
I'm on page 23.
Yes.
Okay.
It's number 29.
It's in
It's
number
the second
20.
line under 20.
Got it. I see it now. Okay.
The next is drug and or alcohol testing. There's a little bit of verbiage different, but the overall spirit of it is the same as what the board approved.
And for drug and alcohol testing, we don't need to put marijuana in there? Or is it in there and I'm just not reading it correctly?
Well, I'm not sure if it needs to be required because they're being tested for that. I mean, I would, it doesn't really say alcohol testing, does it?
No, it's based on the offenses, I believe. So it can be personalized to what.
Oh,
the
I
issue-
see what you're talking about, the
Number
the
30.
title, drug and alcohol testing. Okay.
But would marijuana count within the broad drug?
Yeah.
It probably wouldn't, but the fact that we're telling them, and I'll let Kelsey opine on this, the fact that we're telling them to abstain from marijuana if they test positive during the it's really about the content of number 30, and that's talking about the fact that they have to test and what kind of tests they have to
Tested that we
submit
did.
to.
Okay.
Am I? Is that, okay.
So the next changes are in billing system, which is number 32, calendar days, that's it. Billing system audit, calendar days. The only other changes then are, there were in the penalties, there were certain penalties where it said that certain offenses may warrant public reproval. And so instead, but the minimum penalty wasn't public reproval. So in those instances, I just changed it to reflect that the minimum could be public approval.
I have one more too, Kelsey.
Okay.
I have one more, and it's on page 35. And this is where disciplinary guidelines meet reality. I want to make sure that we are all on the same page. Willfully making a false statement on the license application. I think I understand what the board was trying to accomplish, or what previous boards are trying to accomplish here, where we would just outright deny, but I would suggest that a minimum should be a minimum, and there are circumstances in which it would be difficult to prove that someone is willfully making a false statement. Now, we deal with this quite a bit, where the offense in itself is not a major offense, and it's not something that we would deny for, but they may have made a false statement willingly, so we stipulate and we allow them to have a license. If the board really wants us to outright deny these folks, then we would be denying some, for instance, if you have a person who was arrested for graffiti when he was 19 years old and he's coming back to the board, but he made a false statement on his application, do we want to deny that person right to be a licensee?
Have a minimum sum, let's say we will let you start the procedure 6 months, you got penalty, you'll be able to apply it, but you have now punishment for 6 months or something.
So
3 months or
6 months.
something for some violation like this.
So 6-month probation would be a minimum?
Not probation, this is for new applicants, right?
Right.
On a new applicant, somebody wants to be.
Use your microphone.
Make sure can you make sure microphone's on?
Someone apply to a new license and he make relatively small mistake on falsely mistake, but it's not so important. So we'll not go with minimum of revocation. You're not gonna get a license. We can go. You'll get come in 6 months and start the procedure.
So you either have to deny the license or approve the license, and if you deny the license, or
Yeah, but
or a
I'll give you the
conditional-
chance. Today, according to this, that's it. It's a one time. You denied, and you cannot ever come again.
You could come, you
When-
could apply
what's the-
again.
So when is the minimum here? When you said here, vocation, denial, pursuant.
That's why I think it needs to be clarified, and what I was suggesting is, Kelsey's right, if you are just denying someone, you're just kind of kicking the can down the road and you're gonna have to deal with it again. If the person is applying at that point and we think that that person maybe should have a license,
Yeah.
but should be monitored by the board, or should have to go on the record as stating this person is gonna have a probationary license, then we could establish what that minimum is. But outright denial may
Yeah.
not be fair.
No, right now, outright denial, the person can come the next day and apply with the right thing, or we remember yesterday you make a false statement. And what is right now the procedure or the norm or the law?
Well, we currently have different guidelines. So we have guidelines for speech language pathology and hearing aid dispenser.
Yeah.
But what I'm suggesting is that we have a couple of ways of doing this, but typically what we do is we deny a license, and then that person has a right to appeal. And if they appeal, it goes to the AG's office, and then the board staff can stipulate
Yeah.
with that applicant as to what the terms would be for their probationary license. So they issue them a license, they revoke it, and then the revocation stays, so they're put on probation.
Oh.
That's better than outright denial. Because outright denial means you'll never get licensed,
Yeah.
or you
Okay.
won't get a license.
So we want to prevent of the applicants right now to go to appeal and to go through all thing, and we will correct it up front with something.
So what we need is for the board to tell us what would be an acceptable minimum for a person who makes a false statement.
A
Not the most,
white lie, something small.
yeah, not the most egregious
Yeah.
false statement,
Yeah.
but maybe something that's a
Yeah,
little more
I
minimum.
thought the simple thing is just delayed for a few months.
So the board really doesn't have the ability to control that. So what happens here is that you either can deny the license and then it goes to hearing, but then what would happen is an ALJ or the AG's office would be looking at this and they would say, well, they provided a false statement, and the board's guidelines say we can only revoke, we can only deny. So there's nothing, we can't give this person a license. So what Paul is suggesting is that you deny the license, and if they appeal, then you have the ability to say, well, because your situation warrants the minimum and rather than the maximum penalty, you can be put on probation for 6
Yeah, I
months, a year,
know,
whatever.
but I would like to save the time and money for everybody by going through this appeal circle,
Well-
by the board saying him, hey, wait a couple of months.
I think we have to look
I
at
know.
it from a consumer protection standpoint, and sometimes it is important for these matters to be on the record. So all we need is let's assume that this is appealed, we deny, like you
Yeah.
said. It's still gonna go to an ALJ, and an ALJ is gonna have to make a determination. They're going to look at our disciplinary guidelines.
Yeah.
And our disciplinary guidelines is gonna guide that administrative law judge to determine what would be the appropriate amount to issue a probationary license. So as a board, we need you to give us a guideline as to what that amount would be. Outright denial is not a minimum, that's a maximum.
Yeah.
So what would the minimum be?
Well,
Would it be 6
minimum-
months? Or,
The minimum,
seems like a
that's
lot
what I
of them is
said.
18
I mean, a
months
delay of few
on here.
months.
18 months?
well, it seems like when you look at the minimums, the ones I've seen so far have been 18 months.
18 months?
Yeah, the ones
Oh,
I've
that-
seen up here.
I don't know, it's too much.
I haven't seen a single 6 month actually.
18, just the appeal take almost a year.
Right, but this is after the appeal. This is,
I know, but I'm talking about if,
So this means that if the board was saying, okay, you have to take a certain course, an ethics course or something, that this would, you have to give them some time to do that. This would give the board probation monitor time to talk to that person and make sure that they've met those requirements.
and to make sure essentially that,
what's-
How
what's
about public reproval as a minimum?
That,
be cumbersome.
no, I actually think that would work. Remember, these are minimums. This means that
Yeah.
the board staff still
Yeah.
can determine.
what is
that-
happening today? Today, if somebody, as you said, have years ago, some small violation not relating to the profession.
If someone is willfully making a false statement
Yes.
on the hearing aid dispenser side,
and-
then I believe it's outright denial. If someone is making a false statement on the speech language pathology side, it's considered unprofessional conduct. So right now, there's wiggle room on how the board determines that, because we have two different sets of disciplinary guidelines.
Can we change it also to unprofessional on the?
Well, it is
hearing aids?
unprofessional conduct, but what I'm saying is, on the hearing aid dispenser side, it's very specific. It's not that specific on the other side. So we're looking at the proposed document, and what we are proposing is outright denial. I think that there's.
I think that should be a maximum,
Right, and I think
and
that
then the
public approval
minimum
would be a good
would
minimum.
maybe be a
No,
public
of course,
reproval.
I
Yeah,
mean,
So they have
Of course, denial is the
Yeah.
maximum, upright denial. It's
but
not-
right now on page,
I think maybe the maximum will be death penalty.
so,
So I think that Karen has made a good suggestion,
Yeah.
that a minimum is
Yeah.
public approval, and that gives board staff and
Yep.
to work with attorneys and come up with
Yeah.
attorneys.
DAGs. Okay,
Well, especially after finding out it happens frequently.
it does happen
Um,
frequently.
I did ask the question of Paul, does this happen very often? And he said frequently. In that case, yeah.
Yeah.
I want something.
And when we go out and talk to programs, we tell them, do not lie on your application,
Yeah.
because that's something people think that, it's not gonna come up, and we're gonna talk a little bit about that in when we talk about legislation, some of the changes that are happening in legislation. That
well,
are
yeah,
impacted
on
by
legislative,
this.
we're not allowed to ask them about criminal records, right? Or that's just,
No, we
I
are
know
allowed to.
employers aren't allowed to anymore.
But we are.
We are,
currently.
okay.
Anything else, Kelsey?
They have
Okay.
to complete a background check and have a certificate of clearance.
I guess we are, but employers in general aren't allowed to ask anymore.
We're done presenting this part.
I can answer that. In our field, because we're based in medical settings and in schools, it's, I can't think of any, it's not mandatory to have background checks because we have to have clearance from DOJ and FBI, yes, for our license, but also if a therapist is going to go in a school district, they're going to assist upon it. If they're from an NPA or NPS, it's written right into the regulations in California, they have to have it. Medical settings are going to require it too.
Okay.
And when you're applying for graduate programs in speech language pathology, and I'm going to guess audiology as well, you have to have completed a certificate of clearance.
But as
So
far
it's
as our
very
current
common.
laws, we do ask the question. We ask it upon renewal too.
Okay.
We're ready for a motion if there are no other comments.
Motion to accept it.
There's a specific motion that Kelsey will help us.
Motion to, perhaps the motion could be a motion to approve the proposed language with the additional changes discussed, to delegate, and to delegate, oh, you have it.
I do.
As modified, direct the executive officer to take all steps necessary to initiate the rulemaking process, to authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, to notice the proposed text for a 45-day comment period, and we no longer use that part, but,
Period?
yes, period.
Okay.
End of sentence.
I move.
It's been moved. Is there a second? Second. Okay, we'll call for the vote. Amnon? Oh, wait, is there any more discussion by the board? Any discussion from the public? Okay, then, Amnon?
Yes.
Aye. Yes.
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 Okay, so the next item on the agenda is number 13, legislative update, review, and possible action. And because I know you guys get tired of hearing me talk all the time, we've invited someone from legislation. And you're going to help me pronounce your last name. It's Alex
McElwraith.
McElwraith.
Yeah, you got it.
Our legislative analyst could not be here, so he's going to present two bills that impact the board.
Sure.
Thank you.
I also have copies of the bills here in case you need one.
Okay. The first bill that he's presenting is AB 2138, and that actually has to do with denial of applications. So I think that this is a really good, timely segue into this.
All right. Well, I'll start by just thanking the board for having me here today. My name is Alex McElwraith. I work in the Legislative Affairs Division of the department, and I'm here today to speak generally about AB 2138 and AB 1659 and provide an overview of what those bills do and where they're at in the legislative process. So AB 2138, that's our first bill. That one's authored by Assemblymember Chu. And as the executive officer mentioned, this one deals with criminal convictions. I would preface my comments by noting this is only a high-level summary of the bill, and this bill makes significant changes to existing law in an attempt to reduce barriers to licensure for those with criminal convictions. So some of the key provisions in this bill include a restriction on boards that would only allow for the use of convictions in licensing determinations if the conviction occurred in the past 5 years. This would exclude violent felonies from this 5-year limit. The bill would also require that criminal convictions be directly and adversely related to the profession for which a license is submitted in order to be the cause for denial or revocation of a license. As you probably know, this is a change from current law, which sort of is based on crimes that are substantially related rather than those that are directly and adversely related. The bill would also prohibit a board from denying a person a license based on the conviction of a crime or on the basis of acts underlying a conviction for a crime if the conviction has been dismissed or expunged or if the person has made a showing of rehabilitation. The bill defines what a showing of rehabilitation would be, those two things being, you would only need to meet one of these, by the way. The applicant or licensee has completed the criminal sentence at issue without a violation of parole. And number two, the applicant or licensee documents that he or she has worked in a related field continuously for at least 1 year prior to licensure, or successfully completed a course of training in a related field. Additionally, the bill would limit the length that the board can require for a probationary license to 2 years. It's common right now for a lot of programs in the department to have probationary licenses that last for about 3 to 5 years. So this is also a significant change for some of the programs within our department. And in terms of where we're at in the legislative process, this bill actually just passed off of the Assembly floor yesterday. I think there are 45 votes in favor of it. It was mostly a party line vote, but there were some Democrats who were opposed as well. So that bill had made it through the Assembly, through their policy committee, through their fiscal committee, and the floor. And now basically the next steps for this bill, it's going to have to go through the Senate, the same process, go through the Senate Business and Professions and Economic Development Committee, the fiscal committee there, and pass the floor. And if it's amended in the Senate, which is probably pretty likely, then it will have to go back to the Assembly for concurrence. All of that has to happen before the legislature adjourns at the end of August. If you'd like, I can go on to the next bill, or do you guys want to discuss that?
I want to make sure, does everyone understand how this impacts us, or does anyone have questions?
Well,
Any board members have questions on this? Yes.
So I actually do have a question. So when we have DUIs, how would that, we have a lot of DUI cases. Is that substantial, or is that, which one is it?
You know, I think currently it would be related. So it would be related. What was the term that you just used, Alex?
They want to change it to directly and adversely related. Right,
Right.
now it's substantially.
Okay,
is
so-
what you're referring to, but I think it sort of depends on what profession is
Right.
being regulated, what would be substantially
Exact- and-
related.
And that's why I'm asking you, which one would it be for us?
For us, it's, go ahead, Kelsey.
Well, so that I think is a little bit difficult to ascertain at the moment because right now we rely on case law for, let's say, for a DUI to show that that's substantially related. So I'm not sure what the parameters would be for the language in this bill.
So it would be to be determined is what it's, if this bill passes, that would be a to be determined type of.
And currently, all licensees have a right to due process. Licensees, the board has the burden of proof, which is typically a high burden of proof. It's clear and convincing because all of our licensees are treated like healing arts licensees.
Mm-hmm.
So whenever we seek to deny or revoke, the licensee still has a right to due process. What happens with this bill is this bill puts a lot of additional burden on the board. Like, for instance, if we were going to issue a probationary license, as Alex mentioned, it would have to be limited to 2 years. There may be circumstances in which you want someone to test for more than 2 years. In addiction and recovery, 2 years is not a significant amount of time at all to test someone. There were other questions?
Well, yes, that's related to what some of our probationary periods are 5 to 7
Yeah.
years, depending on how serious it is. So this would limit us no matter what. To 2
In many
years.
areas, in various. That's correct.
Actually, if you look at the disciplinary that we just looked at, a lot of them are 3 years.
Right.
So then we would have to change it.
I would also just point out for you on that subject of what really constitutes directly and adversely related. The bill doesn't define what that term specifically means, but it also doesn't in current law define what's meant by substantially related. And as Ms. Pruden had mentioned earlier, there's case law that sets the precedent for that currently. So sort of how this differentiates from that.
How else will this bill affect the board?
It's hard for me to say exactly how it's going to impact you guys because I'm not all familiar with your program, to be honest with you. And like I said earlier, there's other provisions in here as well, reporting requirements. You're going to have to track things relating to the denial of license applications. But fundamentally, it would suggest that it might really change how you guys do licensing.
Our primary mandate as a board is consumer protection. I feel like this bill could limit our ability to protect consumers. For instance, with a 5-year limitation, if there was elderly abuse or fraud in someone's past, we would not be able to monitor that person. We would have to issue them an outright license. In a previous board that I worked with, if someone had a serious drug conviction, even if it was some time ago, because that person was dealing with drugs, administering drugs, that person, the principle behind that was consumers have a right to know that that person has had a drug conviction in the past if we are going to issue that person a license. So from the standpoint of consumer protection, I have some real strong concerns of how this would hamper our ability to protect consumers as a board.
Should
So,
we be writing a
you-
letter of opposition then?
I was going to ask you, Alex, if you could just comment on how other boards have, if you're able to tell us how other boards have looked at this bill.
Sure, yeah, actually, it sort of varies on a case-by-case basis. Some boards haven't had the opportunity to meet, how the meeting schedules go with that, but there are a number of boards that have taken an opposed position. I think some of those are the Barbering and Cosmetology Board, the Contractor State License Board, the Dental Hygiene Committee, the Medical Board, the Optometry Board, the Pharmacy Board, the Physical Therapy Board, the Physician Assistant Board, the Psychology Board, the Respiratory Care Board, the Veterinary Medical Board, and the Professional Engineers, Land Surveyors, and Geologists Board. Those have all taken an opposed
And
position.
like
those,
they were
you've
probably
named all the
pretty-
healing arts boards
Yeah.
in addition to others. Can I just ask, what was the, if you can just broadly describe to us the impetus for this particular law?
Yeah, the author is really trying to get at recidivism, and the argument is that, well, there's barriers to entry for people with criminal convictions, and arguably you try to give these people a job, then they're less likely to commit other crimes, and that can improve public safety.
Okay. So I think in regards to us, that's lauded in certain professions because we're dealing with human beings with issues of hearing and speech and language. I think we're at a whole different level than perhaps, I'm just going to make something up, like perhaps being a gardener or something like, I'm not, it's just there's a different level of concern there.
So I ask so we can make a position to oppose it as other boards done and relate to the.
Yes, we can take a
Correct.
position. I just wanted to point out, if I could just add to the question on what brought this about or the impetus. In looking at the little Hoover Commission report, there were issues with process. And I can attest to that sometimes the process can be difficult for someone with convictions. We have to do research, we have to have information, court records. But that's why when we look at our disciplinary guidelines, outright denial isn't the best option. So we want to improve that process by having good processes in place in our office, policies and guidelines. So I just wanted to add to that. And yes, Amnon, we can take a position.
Yeah.
And I suggest also to the legislators that they will write in the law that everybody denied by the board, they will hire them as a staff member for their offices.
Always has a solution.
I have a question. When you remember when we were talking about the disciplinary stuff on our last thing that we spoke about, and you were saying something like graffiti, is that a criminal? Is that considered a criminal offense?
That could be a criminal conviction, yes.
Uh-huh.
But just because someone has a criminal conviction doesn't mean they would be denied. In that case, the example I was given was someone who willingly made a false statement. And I didn't want to have to apply a disciplinary guideline to someone who maybe
Smoked marijuana 5 years ago.
Tagged a train car and when they were 18 and 10 years later is applying for a license as a professional.
Okay.
So you said it excludes any type of violent crime?
Yeah, it was violent felonies.
Violent
Those are excluded
felonies.
from the 5-year rule. So there's this washout period where you can only use convictions within the past 5 years unless those are those violent felonies.
Okay.
Marcia, did you have a motion?
No.
I have a question to the lawyer, to Kelsey. I personally know David Chu. If you guys are going to make a motion, I think, should I not abstain?
If you think that your relationship is going to sway your vote, then I would suggest that you abstain.
Amnon, did you want to make a motion?
I'll move that the board will write an opposition to this Assembly Bill 2138.
Is it seconded?
I second it.
Any further discussion? Any comments from people in the audience? Linda?
Good job.
Okay. It's been moved and seconded. Let's call the roll.
Yes.
Aye. Yes.
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 Abstain.
So as far as follow-up goes, is it Paul who will be writing the letter?
I will draft a letter for G. Parker's signature.
Okay, got it.
All right, well, I guess that takes us to our next bill, AB 1659 by Assemblymember Lowe. This bill is a lot more simple than the last one. So this bill would authorize a healing arts board to establish a lower renewal fee for an inactive license. This would be completely optional. It's not required. Just give some flexibility to the programs to determine what's best for them and their licensees. The bill would also prohibit a licensee with an inactive license from representing that he or she has an active license. And really the purpose, drive behind this bill, is to provide all the healing arts boards with the option to reduce the renewal fee for inactive licenses and clarify existing laws as they relate to those inactive licensees. In terms of where it's at in the legislative process, this bill sailed through the Assembly, no votes in opposition to it. This was back in January. They haven't scheduled a hearing yet in the Senate, but that's common. They just passed the House of Origin, or they will pass the House of Origin deadline today. So again, for this bill, in the next 2 months before the legislature adjourns in August, the bill's going to have to be heard in the Senate Policy Committee. the Senate Appropriations Committee and on the Senate floor. That's it.
Alex,
Do you have any questions?
there have been other versions of this bill in the past, right?
I know there's been some other bills on renewal fees and inactive license types, but I don't, maybe those were specific to non-healing arts boards.
Or they were mandatory and this one gave the board the ability to choose whether they wanted to?
I'm not too sure, but
I don't know. I know that other boards have specific statutes for their particular licensee population, where they can change the renewal fee. So it may be, I don't
Okay.
recall if there's been other bills like this, but I do know that other practice acts have inactive license statutes that are specific to them.
Is there any significant appropriations associated with this?
I think it depends by each program. I mean, you might have to do regulations, and if you don't have staff to do that, maybe there's a fiscal impact, but, I think it varies by program to program. Probably for the most part, no, but I can't confirm that today.
Yeah, well, it's not saying that we must do that. It says that we have the option. So it's just creating more options for us for inactive licensees.
Right, because right now you use the general inactive license statute, and that requires that it be the renewal fee of the board, so.
The people with
Inactive licenses? Probably not common enough because we found in our CE audit that there were several licensees who were in a retired status, but probably needed to register or be licensed as inactive because they didn't think they had to fulfill the CE requirements. I think that it's common for licensees to want to maintain their license, and they're just not aware of the law that allows them to have an inactive license.
So that's a really interesting thing. So maybe you can define to us what is meant by an inactive license.
An inactive license, and Kelsey, you could probably help us more with this. My understanding is you're licensed, but you're not practicing.
Right, you're not active. You pay the renewal fee, but you do not have to comply with the CE requirements. But I believe there is also language that you're not practicing either.
And the existing law, you can see it in the bill that Alex gave us. That's actually it's part of the current code. So if you decide to become active, then you have to go back to complying with the continuing education requirement.
So I guess what I'd ask is what would be examples of why would someone want inactive status? They want to be able to say that they're licensed, why would someone want to do that?
I mean,
It could be
as
for-
a different licensee, I mean, if.
I don't know why they would want to do
Yeah.
it, but I know that they do.
Yeah,
I
I mean,
know
if
I
you've gone through the schooling or if you've been practicing for many years, but you don't, because the alternative is an expired license. So, and I think with the
Okay.
old systems of CAS and Breeze and all of that, the way that it's personified within the system caused a lot of licensees to dislike that status of expired or failing to renew essentially.
Okay.
So I think a little bit of it is a status.
Definitely.
And I know several other boards, I believe like for dentists, they automatically give you a retired license at a certain age. You're still able to practice, but it's more of a recognition of your time. So I think a little bit of it has to do with just recognition of status.
Could it also be that you're planning to not work for a period of years and then come back to work?
Absolutely.
Yeah, so to me, that would be,
That's a very good example. Someone
Yeah.
moves out of state
Yeah,
for a time and they want to keep their license, not have to retake the test
yeah,
if they're
Yeah.
out of state for 5 years. So they may decide, I want to be inactive, and then come back and resume being active.
okay, that makes sense to me.
Any other questions? All right. Thank you so much.
Absolutely.
That's for any public comments on that one.
Are there any public comments?
We're on number 14.
Where's my sheet? Items for the agenda.
Yes.
We're now on item 14, which is items for future agenda.
And
should
also
say
future
that, yeah.
board meeting dates.
Yes, I don't want to forget about the subject that we forgot for this meeting, the supervision of hearing aid trainees. That was I want to ensure it now that it will be on the next meeting.
Okay, I'll give you my assurance.
And then we also want to be talking about RPE telesupervision regulations.
Three PA person left, so I'm not sure, did somebody already talk to Mr. Frazier?
Yes, I've already addressed it with both.
Will be on the agenda.
I'm not sure if it'll be on the agenda, but I approached the topic with them and I informed them of what the board is doing.
I thought the question earlier was to get it on the next agenda, but she left.
I had a conversation with her. I didn't know why she was here though.
Okay. And Kelsey, are there any additional SLIPA issues we need to deal with? Or is it just now going to move through the regulation process?
No, not that I'm aware of, so we'll move through the regulation process with that, the motion and everything.
Okay.
I remember the last board meeting, we had a topic about the California Children's Services. Has that been resolved or are we still, is that still in the air?
That's you.
It's ongoing.
Oh, okay.
We submitted a number of concerns,
I
sorry.
would just recommend
Oh.
not discussing it,
Oh,
but
okay, because not on the agenda.
So
Yeah,
should it be a
it's
future
moving
topic?
forward, and I can report on it.
Okay.
Okay,
Next.
so we'll add
Okay.
that to our items.
Sorry.
Locked hearing aid?
Is there anything to talk about as far as hearing aids?
I don't recall any resolution to how we were going to address that, so it probably isn't bad to put it back on here.
Well, if we have, I would encourage us to do that if we have something to present, but not just to put it on there unless we have somebody that's willing to take that on. But I do have another one that I want to remind you of.
I'm willing to take it on. You mean in terms of investigating further?
I think we've talked about it, but what do we want to do with it? I think it's a pretty broad topic.
Yeah, let's put it on the
It is,
agenda
but
and talk again.
it is a consumer protection issue.
Well, if nothing else, you could give us an update. Yeah, what's gone? Just a quick update.
And I did actually just think of one, but Kelsey, tell me if it's no. Do we want to talk about SLIPA telesupervision regulations at all?
so. Not, well, the supervisor does have the ability to electronically supervise in certain situations, so
Yeah.
believe that it's already covered in the current regulations.
All right, okay.
What was the other one? Paul, you said you had.
What does the board wish to do about the hearing aid? We said something about the hearing aid dispenser, a practical exam for audiologists,
Oh,
or the audiology dispensing exam.
Oh, yeah.
yeah.
Yes, that's right. Any other suggestions?
We also have dates and locations on item number 4. Our next meeting, I think we tentatively selected August in San Diego. I think Amnon Shalev thought that being in San Diego in August was better than being in Sacramento in August and San Diego in November.
No, I thought being in the winter in the south and,
Right.
and summer in the north.
As long as
And San Francisco is good in the summer,
And I can just, just as far as San Francisco goes, San Francisco can be really difficult to come up with contracts, hotels. Logistically, it's becoming more challenging.
I'm
But
fine with San Diego.
But San Diego seems to be, okay. So we'll go with those next 3 locations for now.
I thought San Francisco, since we have the campus, it's free and.
Well, I'll tell you that San Francisco is difficult, even for staff and for guests to get in and out of there, as opposed to, a place like Sacramento or even going into Los Angeles and San Diego. It's actually more difficult for us to get in and out of there than it is just to fly all the way to San Diego.
I'm very of San Diego because Los Angeles and San Francisco are sanctuary cities. You know this? It's hard to get there and get back.
He made the observation yesterday traveling at the airport that all the San Francisco morning flights were delayed or canceled because of the fog.
Oh.
What other boards have been doing is many boards have been going to outside locations like Berkeley, Oakland, Lafayette, some of those other cities surrounding the Bay Area.
Outside
Because
the cities,
it's
much
difficult to
better
get in and
than
out of the
the
city.
center of the city.
How about
But
San
for-
Jose? How about San Jose?
South Lake Tahoe.
That's expensive.
Are you suggesting San Jose for August, or that we stick with?
No, I'm just
Okay.
saying that rather than San Francisco, we could consider San Jose. No, I'm not suggesting
Okay.
it for
Okay.
August at all. Maybe for the May 2nd, 3rd of 2019.
We can look at the San Jose, Santa Clara area.
San Jose, Santa Clara, yeah.
Sure.
Alameda County. Alameda County, that's where. Alameda County,
Alameda.
that's what it's called.
Okay, I think we have all the information we need. I think we have all we need.
Thank you all. We will see you in San Diego. Is that where we're next?
San
See you in
Diego.
San Diego.
All town.